This fake shit right here. They had like this and that.
You good with that?
Yeah, I need to.
Okay, yeah, yeah.
This, man, this fall.
Good jury.
Man,
And we added the word O'Donnell and Lively was a correct course.
man, this fake shit.
Jackson's down here. Maybe, yes.
That's crazy. Man. You gotta try to get a conviction out of me by lying. Man.
Did you not do the over?
Man, we could take a lie detector. Do they got a lie detector? That stuff's not admissible in court. Man, this shit fake right here. I want to know who this person is. Yes, yes.
Some reason I thought he was down there.
He might be, I didn't think.
That's fine.
Who was down, over down with? We had columns there on there, and over down.
This all fabricated. I promise you.
I'll find out.
And it was, well, good.
That's fine.
Grand jury, okay.
Wait,
Which landowner complaining about that?
What doesn't he?
Got the greatest job in the fucking world.
Hey,
That's why he knows to pay $10.
I don't get paid for what I get paid for. You know, and I'm very much.
Why don't you tell Pleshnik and Hammercheck we should get the same deal?
What's that?
You should tell Pleshnik and Hammercheck we should get the same deal,
What's that?
that we stand ready 24/7,
What?
that we should be getting paid.
All rise. Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presiding.
We're on the record. This is case number 22 CR 000146, State of Ohio versus Ramon V. Hawley. Mr. Hawley is present in court, represented by counsel. Attorney Corey Hinton, representing the State of Ohio, is Assistant Prosecuting Attorney Lawrence Geigrich. The matter is before the court at the request of Mr. Hawley. He filed a motion to discharge counsel and to go pro se on December 21st, 2022. Basically complaining of how Mr. Hinton is appearing to him to handle his case. He has made some general and some specific allegations, and he requests that he be self-represented in the trial. Mr. Hinton, you've seen the motion.
I have, Your
All
Honor.
right, and bring me up to speed.
Okay, thank you, Your Honor. I did have a chance to review the motion. I did have discussions with Mr. Holly regarding the allegations and complaints in said motion. I explained to him why certain motions were filed or not filed, and my mindset and strategy. We discussed some additional items, made sure that he had any documents that may have came supplementally or whatnot, set up a plan for him to view the videos, which are difficult to transcribe over to form viewable in the jail. But we did have what I viewed as a very productive conversation to rectify the relationship and address all of the concerns that he lodged. And I think that there may have been some misunderstanding, but that it at least appears from my point of view that we're on the same page and ready to move forward as a team.
Okay. And Mr. Hawley, do you agree with Mr. Hinton?
Yes, Your Honor.
Okay.
I did see him yesterday. He brought me up to speed of what was going on.
Move the microphone closer.
He brought me up to speed what was going on, and I just, have a concern with, seeing the disc so I could be able to help, look at certain things so I can help him with my defense. Because I'm having a concern about why the prosecution is not allowing me to see the identity or disclose that the identities is not being disclosed to me about who these informants are. And I feel like I have a constitutional right to know any witnesses that the prosecution has against me, and any, medical, history that they have that can help me in my defense, and any, bad criminal records that they have. And I also wanted to get the East Lake camera because it's going to show before Agent 91 got a warrant for my to go through my cellular phone, that the officer of the jail went through my phone without my approval, and the camera would show that he went through my phone, my cellular phone, without me telling him that he could go through my phone. Period. On February 12th of 2022.
All right. And Mr. Hinton, you're well aware of all his
I did.
concerns.
Yeah, those were some things that we've gone over before, we went over again, and did come up with a strategy to address.
Okay. All right, good. So, and the court notes that the defense also filed a motion to suppress evidence. The state will be given an opportunity to respond to that, and then I will put that on the calendar. I probably won't be the judge on the case because I'm moving on. So whoever replaces me will take over the case. It'll be governor's appointment. So the trial for next week is obviously off. Anything further?
Nothing further from the defense, Your Honor.
Anything further, Mr. Hawley?
Well, Your Honor, when I'm gonna be able to be notified about the so-called informants, the identity of the informant?
Well, between your attorney and the prosecutor, your attorney will have to have that disclosed to him because you do have a right of confrontation, and you do have a right to know, criminal history and things of that sort. If there's any deals that have been made, that stuff will be revealed to you through your attorney.
I'm sorry to cut you off, because the driver, Carl Harkins, He's next door to me, and I don't know what he
Next door, you mean in
In
the
the-
adjacent cell?
here on another criminal complaint for beating on an elderly woman. And I know the prosecution basically trying to use him, like he said in the card, to put the crime on me. And that's not fair, because when we was booked into the county jail, they found drugs that was thrown out his window inside. The drug that they found thrown out his window was inside his house. The police said they did an observation, but they never seen me with no drugs on me, period. You know, no fingerprints, period. And like I say, the money that was found in his house, they put that money on his books but took my money, and that's not fair. That's not equal
Okay,
protection
well,
of the law.
first off, don't say too much, because this is being recorded and anything you say can be used against you. But your attorney knows all of that.
Okay.
And so he will work to your best interest in making sure whatever needs to be brought out to create reasonable doubt will be done.
Okay.
I've known Mr. Hinton for a long time. He's an excellent attorney.
Yes, sir.
Anything further from the state?
Nothing.
Okay. All right.
Thank you.
I'll talk.
All rise. This Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presiding.
May be seated. We're on the record. This is case number 22 CR 001185, State of Ohio versus Samuel J. Trost Jr. Mr. Trost is in court, represented by counsel. Assistant Public Defender Ashlyn Carroll, representing the State of Ohio, is Assistant Prosecuting Attorney Carolyn Mulligan. The defendant was here on December 1st, 2022. He pled guilty as charged. One count of aggravated arson, a felony of the second degree. I referred him for a pre-sentence investigation and report and set sentencing for today. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated December 28th, 2022. And the victim would have been notified and requested to provide a victim impact statement, and I have not received that, and I have not received anything from the fire marshal. And the pre-sentence report shows jail time credit to date of 224 days. But what was he in the custody of the other agency for? For 149 days. 145 days in the custody of another agency. What agency was that? Okay, all right. But he was held on our warrant. Okay. So 224 days, everybody agree that that's the jail time credit?
Yes, Your Honor.
Okay. Any inaccuracies, any modifications needed to the PSR?
Not that I'm aware of, Your Honor.
Any reason not to proceed?
No.
You may go first.
Thank you. In this case, we would ask for community control sanctions to be imposed for Mr. Trost. We do believe that non-prison sanctions adequately protect the public and punish Mr. Trost for this situation because the factors indicating recidivism is less likely outweigh those indicating it's more likely. Firstly, I do believe that there is genuine remorse here. Mr. Trost did take responsibility for the situation by admitting his conduct, both when initially interviewed by police and also by pleading guilty as charged in the beginning of December. He also has a minimal criminal history. He's never been to prison, and he did lead a law-abiding life for a significant amount of time. There was about a 20-year span. before this incident without any criminal conduct, and so that does show that he has been a law-abiding citizen. We also believe that it does not demean the seriousness of the offense to impose community control sanctions. One factor that I do believe shows that it is less serious is that he did not expect to cause the level of harm to the property that did occur. Mr. Trost, I believe, initially intended to cause a small amount of harm to a roommate, but when shown the full significance of what actually happened, he did show that he was surprised, and that was not what he intended or expected to happen based on what he did. I also would like to place a Reagan-Tokes argument on the record. If a prison sentence is imposed, we would like to object to the imposition of a Reagan-Tokes sentence because it violates certain rights guaranteed to Mr. Trost. The appellate court does disagree, but it's pending in the Ohio Supreme Court, is my understanding, so I would just like to place those on the record. Firstly, that it violates the separation of powers by conveying sentencing discretion and authority to the DRC because they alone determine whether additional prison time is imposed. It further violates his right to a trial and right to counsel when extra time is imposed by the DRC. Lastly, Reagan-Tokes is void for vagueness, as offender's conduct in subsection C is vague. It stipulates only that an offender's conduct shows he is a threat to society, which gives discretion, basically uncontrolled, to impose time. So we would object to any Reagan-Tokes sentence being imposed. Thank you.
Samuel Trust, the law allows you to say whatever it is you want me to consider before I sentence you. Is there anything you want to say?
No.
And do you have any witnesses to present?
No.
No, Your Honor.
Let me hear from the state. Mulligan?
Your Honor, the victim is present and would like to make a statement to the court at this time. This is the property owner.
Good morning.
Good morning.
And would you state your name, please?
Khalid Griffin.
And spell your name.
Khalid, last name Griffin, Griffin.
And you are the owner of the property?
Yes.
And what would you like me to know?
I read the report of this chain of events, and this gentleman had ample amount of time to be able to speak to me as a man residing in my home. You met my family, you met people that I know personally, and you made a bad choice, I do agree, but that choice doesn't reflect on what actually happened. You had ample amount of time to say what happened with you and Megan that morning. And you said nothing. You sat in that chair, clear, consciously stating, oh, I don't know what happened. And so then I asked you to leave, professionally and calmly. So that part about you didn't know what happened or you didn't have time to make a choice, yes, you did. And the fact that the report states that there were multiple fires set, I don't even understand how it is that you thought it was only going to spark a fire and go right out. I want the record to be shown that I lost everything. I worked hard for that.
Can I interrupt you 1 second? The microphone is where you're...
I'm sorry. I apologize.
When you do that, the microphone's not picking it up.
I'm sorry.
So you lost everything?
Everything. All my personal items.
What was the structure damage?
Oh, the entire top floor of the dwelling, the exterior, and the basement. The basement was completely ruined. Completely. When I say I lost everything, man, I told you this when I first met you. I worked hard to purchase that home for my family. I have 3 children. I was sleeping in my car the past 6 months, man, because of a bad choice that you made. And I don't want that to go unnoticed.
Was the structure insured?
The structure, yeah, by the mortgage company.
Pardon?
The structure was insured by the mortgage company.
What was the value of the damage?
$480,000.
And what was your out-of-pocket loss?
It's, so far, I'm roughly, every dime I have, I'm up to about almost 60 grand. My whole salary from last year is completely gone.
And what was that spent on? What types of things?
Framing, roofing, every trade you can think, electrical, HVAC, that's all that's been done thus
So
far.
you spent 60 grand
Yes.
to help rebuild the house?
That's what we're in the process of as we speak it. We're building the house.
Okay, so the insurance didn't cover it all?
No, they didn't. No, they only covered just the other structural damage that was done. So,
What kind of structural damage?
the whole upper portion of the house.
But they didn't cover all the damage?
No, they did not. No, they didn't. They only gave a certain percentage.
Okay, so they
That's
gave
all
you-
kinds of
okay,
you
that's
get.
what it
Yeah.
is, all right.
Yes. So,
So, but can you state with a certainty that you have spent $60,000?
oh, I can stay, yeah, well, a shadow of a doubt, yes. Yeah, I can show you my bank statements.
Okay.
Every dime I had, my whole last year's salary. So me taking away from that, takes away from my children, me being able to provide for my families, man, because of your bad choice. And I don't want that overlooked at all. You should be forgiven. I agree with that 100%. You made a bad choice, you should be forgiven. There's consequences for your actions, especially when you had the opportunity to talk about what happened between you and Megan. You had at least 2.5 hours with me and you talking. And then after I got the initial call from the fire department, that was another almost 4 hours later. So that shit about, excuse my language, that thing about you didn't have time to think about it, man, yes you did. And whatever your emotions allowed you to do, that was a choice. A clear, conscious choice. And I want that to be on the record. That's it, sir.
All right, thank you. Now, Ms. Carroll, do you have any questions of Mr. Griffin as to his out-of-pocket?
So do you have any type of list of all of the different things that you paid for out of pocket, or do you know what the
I don't have it in
percentage?
front of me right now, man. No,
Okay,
I don't.
but you knew that this hearing is coming up.
Justice system. Yeah, no, I did know that the hearing was coming up. I was told that I needed to bring it in. As a matter of fact, I was told that it was an option for me to speak. And so had I known I had to speak, I would have had all those things present.
Oh, you don't have to, but as a
Okay.
victim, you have a right to have the judge consider and order
So why would you make that relevant?
compensation for your out-of-pocket loss.
Oh, okay. I don't need him to talk for me. He just asked me a question. I wanted to answer it to you. What relevancy did that me know?
Right, so I'm gonna ask my next question. now.
Oh, okay, go
The
ahead.
next question is, you said that the mortgage insurance covered a percentage of the damage. Do you know what that percentage is?
Mm-hmm. No, I don't know what it is off the top of my head.
Okay. And do you know the amount that they paid?
No, I can't think of it off the top of my head.
Okay. And the amount of damage that you paid out of pocket? Can you list those specific items?
No, I cannot. I don't have that. No, ma'am.
Okay, and I have no further questions.
And Mulligan?
Sir, you said that you had worked on the framing, buying materials to try to rehabilitate the structure.
Yes, ma'am.
And that amounted to at least $60,000?
Yes.
Okay, thank you. You may continue.
Your Honor, the state would submit that the presumption for prison in this matter has not been overcome by the defense argument, and that a substantial prison term is warranted by the defendant's conduct. The seriousness of the offense, the resulting loss being as extensive as it was, it kind of defies human logic to say he didn't expect the result. Maybe he, after consideration, regretted the amount of damage, but it's an inherently dangerous conduct to light a fire to a home, and the fact that the whole structure was engaged and the losses that the victim has suffered require a substantial prison term.
I've considered the record, the oral statements made, the victim impact statement, pre-sentence report, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden on governmental resources. I've considered these separate recommendations of the parties. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code Section 2929.12. In that regard, there is a factor that makes the offense more serious. The victim suffered serious economic harm. As he described, he had to live out of his car for 6 months. He had to put $60,000 or more of his own money beyond insurance in order to rebuild the premises that the defendant destroyed. The offender's relationship with the victim facilitated the offense. As the victim mentioned, they had significant conversation for a matter of a few hours beforehand, upon which the defendant could have settled his urges and his emotions and chosen other action other than striking out and destroying the victim's property. There are no factors making the offense less serious. I know that the defense said that they did not expect to cause the amount of damage that he did. It's just common sense. If you take a match to something flammable, you have to expect that it'll be destroyed before someone can put it out. And were there multiple sources, multiple points of origin?
It appears as if there was an attempt to light curtains that didn't work, and then the bed was lit. There was something in the report that implied an exterior lighting as well, but we're not satisfied that that was genuine.
Okay. In terms of recidivism, there is a previous criminal history, not an extensive one, but the defendant has been to prison for gross sexual imposition. I can state that there's been a rehabilitation failure after a previous conviction where the defendant was sent to prison.
Your Honor, it was my understanding that he didn't go to prison on that case.
I'm going by my memory. Let me look it up. Oh, what court? The prison was suspended? Who was the judge? All right. And what year was that?
16th of 1995.
95. Okay, so that was when we were the old indefinite sentencing. All right, I stand corrected on that. In terms of making recidivism less likely, the offender has been law-abiding for a significant number of years. There is a presumption in favor of prison, and the court determines that the seriousness the more serious factors outweigh the less serious factors, and the recidivism likely factors outweigh the recidivism unlikely factors. So the court does not have sufficient evidence upon which to override the presumption for prison. Furthermore, even if the court did have sufficient evidence to override the presumption in favor of prison, the court would nonetheless impose a prison term in this case because of the gravity of the what the defense calls a mistake. This is a mistake that you only make once, and it has to be addressed with significant punishment, not only for the defendant, but as a deterrent for others. So there has to be both specific and general deterrence here. The court determines that prison is needed to protect the public from future crime, that a minimum sentence would demean the seriousness of this offender's conduct. Accordingly, it is the sentence of this court that you serve an indefinite term in prison. The minimum is 4 years. The maximum is 6 years, with credit for 224 days. Pursuant to 2929.18, the court determines that you have or will have the ability to pay restitution to your victim up to the amount of his loss. The court determines that loss to be $60,000. That's to Khalid Griffin. Judgment rendered for that amount to be monitored by the Ohio Adult Parole Authority, payable through the Lake County Clerk of Courts. We pay the costs of confinement, prosecution, supervision, treatment, and court costs. Upon your release from prison, you'll be on a mandatory period of post-release control, PRC, for a minimum of 18 months up to a maximum of 3 years. The Adult Parole Authority will give you rules to live by. If you violate their rules, they can return you to prison for up to 9 months for any one violation, and up to 2 years, 1/2 the original minimum term, for all violations in the aggregate. All of that time is already part of the sentence. They don't have to bring the case back through this court in order to administratively impose the additional time. Further, should your violation of PRC be a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired on that 18 months to 3 years of mandatory PRC, and all of that time is part of the sentence. They don't have to bring the case back through this court in order to judicially impose additional time. I mentioned when I took your plea, there are two types of credits because prison is not mandatory in this case. The crime is probationable. There's the 8% credit that can be earned if you are otherwise eligible and you are offered programming for that purpose. The credit is capped at 8% of time to be served or a certain number of days according to the regulations. And there is the 5 to 15% earned reduction of minimum prison term credit. I explained that to you when I took your plea. The prison has to ask for that. The hearing is held in this court in front of the judge, and the judge has to be satisfied that the criteria for awarding that credit exists, and that's exceptional conduct or adjustment to incarceration, as I explained it to you during your plea hearing. Your presumptive, meaning your expected release date, is after serving the 4 years. The criteria for keeping you longer was explained by me during your plea hearing, but basically it comes down to if you commit institutional rule infractions that compromise prison security or threaten the safety of prison staff or inmates, or you commit a violation of law that was not prosecuted, and the infractions or violations showed that you have not been rehabilitated, or by your conduct you show you continue to pose a threat to society, or if you've been placed by the prison in extended restrictive housing at any time within the year preceding the date of your release hearing, or if you're classified by the prison as a security level 3, 4, or 5, or at a higher security level, then your release date would be up to the maximum term of 6 years. They can do that multiple times, but at the end of 6 years, they do have to let you go. So long as you owe any court costs, the state can block your motor vehicle license plates until they're paid in full. You've been convicted of or pleaded guilty to an arson-related offense. You're required to register in person with the sheriff of the county in which you establish residency within 10 days of being released from prison. You're required to provide the sheriff certain information, which includes social security number, full name, aliases, residence address, information regarding the offense, description of scars, marks, tattoos, full identification of where you're employed or attend school, driver's license information, license plate and vehicle information, and anything else that is required by law. You're required to provide fingerprints and palm prints and photographs. You're required to pay a fee of $50 to the sheriff unless the fee is waived. After the date of your initial registration, you're required to re-register annually. You have to update all of that information on a timely basis. The re-registration fee is $25 to the sheriff, and you're required to do this for life. In Lake County, if that's where you establish a residency after your release from prison, the location is 84 North State Street in Painesville, where the registration occurs. I'm going to hand you a document called Notice of Duties to register as an arson offender. You'll sign at line 10 to acknowledge receipt. And I'll print out a copy for you, make a copy of it for you. I have the notice of duties to register as an arson offender signed by the defendant. I've also signed the document. And going to make 5 copies. And I'll provide you with a copy soon. By virtue of the conviction, you're disqualified under both state and federal law from purchasing, owning, possessing, or using firearms or ammunition for firearms. You cannot vote from prison. In order to regain your ability to vote, you'd have to re-register upon your release from prison. You cannot serve as a juror while in prison or on post-release control in any case where the state of Ohio is a party, because the state would be on the opposite side of your case until you are released from final post-release control. You cannot hold any position of public honor or trust. Bond if any is released. If any part of, if you think that any part of my sentence is in error, you have a right to appeal by filing a notice of appeal in this court within 30 days of the date on which I journalize this entry, which will probably be tomorrow. The next day at the latest. That'll give you some idea as to when the time runs. The prosecutor is to prepare a draft of the journal entry and provide it to defense and the court.
You will do that next time.
Anything further?
No, not thank you.
Anything further?
Yes, Your Honor, I would like to place an objection on the record for the restitution order.
Okay, oh yeah, and one other thing, the Reagan-Tokes objection is overruled.
With regard to the restitution, we don't dispute that there was a significant financial loss in this matter, but it's counsel's understanding that the victim was requested to provide documentation on multiple occasions and failed to do so. Not only that, but he has been unable to provide an amount that insurance paid or a percentage that insurance paid, nor an itemized list of the items that he did spend his own money on. Just a general statement that he spent $60,000, his entire income on repairs, and so we don't feel that the court has a basis for ordering a specific amount of restitution in this matter.
But I believe him, and that's all that's needed. He's evidence. What he says is evidence. It's believable. We've always known that the amount of damage was in the $400,000 to $500,000 range. We knew that at the time of the hearing because I made a notation about that. We knew that at the time of the plea hearing. So, but the objection's overruled. Anything else?
No, Your Honor, thank you.
Anything from probation? All right. Good luck.
Do the cats?
April I started it.
April 2021, I guess you got a firm, you got a firm up.
Yeah.
You can't look like you're
No, I'm sorry.
you're searching for the truth.
Yeah.
You just know this shit.
Well, that's why I'm,
Now, you understand, like, how many charges you pleaded to?
four. But that was two alone. Yeah, four in the court, yeah.
Okay, one.
Yeah.
And when is the collection? Each one, I don't even know the exact date.
When was the?
Oh, we talked 1, 2, 3, 4. 4 is math, the other one.
Yeah, that was, yeah.
No, one was 1, 2, 3.
1 and 2 were together in, 21, November 21.
What are you using it?
Heroin and crack.
Okay.
Yeah.
You said the last time you used heroin was 4.
Or actually,
You can't, listen,
oh, yeah.
stop talking. Listen, I can't tell them this stuff using heroin 421. You got busted with heroin 1121. You get it?
Yeah.
Stop talking about it. I'm trying to get you saying. No errors.
Yeah.
Errors are live. Mistakes are live. So, right, so you release at least in November 2021.
Yeah. Yeah.
When
Yeah.
you know what the next date you're going to be correct.
Yeah. So,
We can tell us.
I was thinking maybe this was
Don't say maybe.
422. Then I,
The year, that's just the earliest year.
yeah.
Here's a date on the indictment here, just so.
For which one?
That's a good
The one
question.
that was indicted November 19th of 2021. The
Okay.
other two are info.
The interval, okay. And the one, I guess the one by way of information, the first one, was that also in November 2022?
So
So
the
first,
indicted case occurred in March 15th of 2021.
there you go. Thank you.
The first indicted one, 22 CR 1286, occurred November 16th of 21.
Gotcha.
And then the secret info, the 22 CR 1403, was November 16th of 2022 when he was arrested on the weekend.
Gotcha. Okay. So one for the, so from the top, the first case was in March of 2021, right? And 1 and 2.
Mm-hmm.
What about 3?
3 was,
Was 3 and 4 connected?
no, 3 was another in, no, year.
I'm talking. Just tell me the fucking correct year. I wouldn't let you out of bond right now.
And Mr. Norton, I'm sorry, the 9-day sentence is here. I believe I've done this before, but for
Thank you, appreciate it.
Sorry to interrupt.
Yeah, from the top. That's right, we did my, no, okay.
What?
Let it call you.
I don't know, I think that you guys have something to say. I don't know why you guys don't have to. I don't know.
Sorry, so the first one he was arrested for was the meth. That was in November 2022.
Yes.
And then 1 and 2 were from March of 2021. Okay, I'll say cases 1 and 2.
Well, just the 21 CR 1326, that one is March 15th of 2021.
Gotcha.
And then 22 CR 1286 is November 16th of 2021.
Gotcha. So I'm counting 3 cases there. That's March of 2021, November of 2021, and then the rest in November of 2022.
Correct.
Okay. Which one are you?
The first one.
The first one.
21 CR.
Perfect. Okay. Thank you very much.
You're welcome.
All I'm saying. You're supposed to know too. You can't just shut down. You can't just shut down. You got to be a well of information. So Signature Health is okay with you joining my own.
Yeah.
What is the status of your Medicaid?
Is that, it's, right now, I don't have it. They said they would provide me with, instant temporary coverage, so I got mine.
Did they tell you that specifically, or your mom?
Yeah, my mom.
All you gotta do is
Contact us, he said show up there as soon as I get out of here.
okay. Now, we're gonna file something with Santori this afternoon.
Okay.
Whether you,
Yeah.
if you can file, or that Santori looks to hold. If the judge makes that a condition of the bond, we'll explain that to Judge Santori.
Okay.
When are you doing Santori's court?
When will I do?
Ballpark. I don't know exactly.
It was about,
November, December?
Yeah, about a year.
Oh, it's an old case.
Yeah, because
Okay, so we're saying, and the reason you missed it, you're just kind of like blowing it out.
I peed dirty, and then I had a warrant out here for this one, so then I didn't want to show up in court there.
How long you been on probation before you had that dirty?
I was only a few weeks.
This is an
Month.
indictment. I'll see if I usually have copies of indictments not imposed, so I'll see if I have the others.
Oh,
but
perfect.
At least that's one.
Okay. When you say it was.
It was when I went to Cats in November, in April of
21 or 22? 22 is the year we just went through.
Yeah.
And then, but the answer is not in this.
Yeah, the thing is, I went,
How soon after this incident did you go to Cats? This is March of 2021.
when did I go to Cats? Is that 22 or 21? 21. I got May.
Yeah, thank you very much, appreciate it.
You're welcome.
Yeah, May to July, I was in Cats, and right before I went to Cats, so it'd be May of 21.
May of 2021?
Yeah.
And after that, you never used it.
Mm-mm. I just never showed up.
So no show up to the Florida game.
Correct. We started in Willoughby and got on it over. That's when I never figured that.
Did you show up for municipal court levels?
Yeah. And originally I found it out with the jail, and then I was in Cats when I was supposed to go to court. That's why I lost my bond in Willoughby.
That was around 2020?
Yeah.
When are you supposed to be in court?
Well, it was sometime in the 3 months I was in Cats. Yeah.
Was it like a 90-day program, or did you basically, you ended up staying there?
I ended up staying for 90 days because Cleveland wanted me to stay like a drug court, but then I said, no, I'm not doing drug court, and I stayed there anyways just to finish the program.
What's the location? Is the Cats on Broadway?
Yeah. Yeah.
In the same total thing. Maybe 1 or 2 days ago, either. If you miss the whole, you'd be released. And you'd be voluntary. You'd not miss it under any circumstances. So that would make a difference in you. So, level, the whole time we can pick it up. Kyle.
That's only 5.
Okay.
There's 2 5s, got down to 1. Was that originally going to be a criminal conviction? No, he just gave me probation. And then, was there a reason you were eligible for criminal for prior? I got out this guy attached, and so he said, that was the probation. Okay, so last thing the defense told was about mid 2021. He puts in probation. How long on probation before the violence? Just before. Yeah, this was already there. Oh, okay, here, let me change. So, this was before this episode? This is the minor one? Yeah. Yes. Okay. So it sounds like you went on probation very long. What would you test the baby for? What did you test? Correct. I just asked this because I'm likely going to be doing that now. And then you've only been out, you've been only on probation for an hour. It was my first time being put on the side, 5 weeks. Was it a random school? Or was it something you did when you were there for a meeting? It was just, I was supposed to show up for probation. I showed up for probation, showed up for okay. And then did she tell you that it was dirty, and then you left, or do you know it was dirty? She called me and said it was dirty. Did she ask you to come in? No. But then she said, I got a voicemail that said I was supposed to show up to court then. Who called the phone? Probation, she called.
Rise, this court of common pleas is now in session. The Honorable Eugene A. Lucci presiding.
Run a record. These are case numbers 21CR001326, 22CR001286, and 22CR001403. All three cases, State of Ohio versus Joseph A. Ruvolo. Is that how you pronounce your name?
Yep.
Mr. Ruvolo is in court, represented by counsel. Attorney Eric Norton, representing the State of Ohio, is Assistant Prosecuting Attorney Alexandra Cox. In the 1326 case, Mr. Ruvolo, you are charged in a 3-count indictment filed by the Lake County Grand Jury on November 19th, 2021. Count 1 is possession of heroin, felony 4, a Division C offense. Count 2, possession of cocaine, felony 5, a Division B offense. And count 3, illegal use or possession of drug paraphernalia, a misdemeanor 4 offense. And there are forfeiture specifications attached to each. It's my understanding in that case, you have an agreement with the state whereby the state would find acceptable and you would be willing to provide your plea of guilty to a lesser included offense to count 1, making it a felony of the 5th degree, possession of heroin, and the forfeiture specification, and count 2, possession of cocaine, felony 5. So you'd be pleading guilty to 2 felony 5s in that case. Is that your understanding?
Yes.
And how we get to a felony 5, the lesser included offense on count 1, is that it does not equal or exceed 1 gram, correct?
Correct, Your Honor.
In the 1286 case, you are charged on December 22nd, 2022, in a prosecutor's information, 1 count, possession of cocaine, felony 5, with a forfeiture specification attached to it. A felony 5 carries a maximum penalty of 12 months in prison, maximum fine of $2,500, maximum driver's license discretionary suspension of 5 years, and forfeit all contraband and instrumentality as mentioned in the forfeiture specification. Do you understand the potential penalty?
Yes.
And do you understand that you have the right to have the Lake County Grand Jury consider the evidence as presented by the prosecuting attorney, and for the grand jury to determine the charge or charges? In doing so, they could land on the same charge we have here. They could charge you with something more, something less, or nothing at all. The point is, it's totally up to the grand jury. Do you understand that?
Yes.
And have you discussed the decision about waiving indictment and pleading guilty to a prosecutor's information with your attorney?
Yes.
And has he answered all of your questions to your satisfaction about that topic?
Yes.
And then, with regard to the 1403 case, you are also charged in a 1-count information filed by the Lake County prosecuting attorney on December 22nd, 2022. And the charge is aggravated possession of drugs, felony 5, a Division B offense, with a forfeiture specification for contraband and instrumentalities. That also carries the same penalty. You understand that?
Yes.
And did you discuss waiving indictment with your attorney on that?
Yes.
And so on both of the second and third cases that I introduced here, do you wish to give up your right of indictment?
Yes.
Going to hand you a document called waiver of indictment, one for each case. Make sure you've read them, make sure you understand what they say, make sure you agree with what they say, and if you sign them only because that's what you want to do. Counsel, if you would approach for the waivers.
Your Honor, received both waivers of indictment, the 22 CR 1286 and 22 CR 1403. The witness and defendant have both documents from the court. Please have to sign them tonight.
I'll make the waivers of indictment part of the record in each case. So we have a total of 4 felony 5s with specifications, forfeiture specifications to each. Between the 3 cases, before I can accept your plea of guilty in these cases to these charges, I have to determine if you know and understand the rights you are giving up, consequences of a guilty plea, and that you are entering the pleas of guilty of your own free will. How old are you?
42.
How far did you go in school?
I graduated high school, some alternative adult education.
And do you have the ability to read, write, and understand the English language?
Yes.
Do you hold any kind of state-issued occupational license or certification?
No, I'm certified electrician.
All right, but nothing issued by the government where the government can take it away if you're convicted?
No.
Are you a U.S. citizen?
Yes.
Are you currently under the influence of any drugs, alcohol, or medication of any kind?
No.
Have you taken any within the last 48 hours?
No.
Have you ever been medicated, hospitalized, or treated for any mental illness in your life?
No.
Have you received a copy of the indictment in the one case and the information in the other 2 cases?
Yes.
Did you read the charges?
Yes.
Do you understand the charges?
Yes.
Did you discuss those charges with your attorney?
Yes.
Did he answer all of your questions to your satisfaction about the charges?
Yes.
Do you agree that those charges describe what you did here?
Yes.
And do you wish to plead guilty to those charges?
Yes.
except for count 3 in the first case. That's going to be dismissed. So I've been handed in each of these cases a document called Written Plea of Guilty. It consists of 4 pages. And you probably went over those documents with your attorney before we started the hearing, is that correct?
Yes.
And did you read those documents?
Yes.
Do you understand them?
Yes.
Did you discuss those documents with your attorney?
Yes.
Did he answer all of your questions to your satisfaction about those documents?
Yes.
Do you agree with what they say?
Yes.
And do you wish to sign them?
Yes.
I'm going to go over the charges you are proposing to plead guilty to so that we are all on the same page. In the 1326 case, count 1 would read that on March 15th, 2021, in the city of Wickliffe, Lake County, Ohio, you knowingly obtained, possessed, or used heroin, a Schedule I controlled substance. That's called possession of heroin. It's a felony of the 5th degree. It's in violation of Revised Code Section 2925.11, and it is a Division B offense when it comes to determining whether I should impose prison. Do you understand that charge?
Yes.
And is that the first charge to which you wish to plead guilty in the 1326 case?
Yes.
Count 2 says that on March 15th, 2021, in the city of Wickliffe, Lake County, Ohio, you knowingly obtained, possessed, or used cocaine, a Schedule II controlled substance. That's called possession of cocaine, felony 5, Revised Code 2925.11, a Division B offense also. Do you understand that charge?
Yes.
And do you wish to plead guilty to that charge?
Yes.
Both of them have identical forfeiture specifications that say that at the time of the offense, you had in your possession property which would be either contraband or an instrumentality of each of these offenses, and you would forfeit the items being heroin, cocaine, isotonitazine, a pipe, and packaging. You understand that?
Yes.
And do you wish to plead guilty to that?
Yes.
In the 1286 case, count 1 reads that on or between November 16th and November 17th of 2021 in the city of Mentor, Lake County, Ohio, you knowingly obtained, possessed, or used cocaine, a Schedule II controlled substance. That is possession of cocaine, felony 5, Revised Code 2925.11, a Division B offense. Do you understand that?
Yes.
And do you wish to plead guilty to that?
Yes.
Attached to it is a forfeiture specification for contraband and instrumentalities, and you would forfeit the cocaine, pills, tablets, capsules, a cigarette pack, paper fold, pipes, and packaging. Do you understand that?
Yes.
And do you wish to plead guilty to that?
Yes.
And in the 1403 case, count 1 says that on November 16th, 2022, in the city of Willoughby, Lake County, Ohio, you knowingly obtained, possessed, or used methamphetamine, a Schedule II controlled substance. That's called aggravated possession of drugs. It's a felony of the 5th degree. It's in violation of Revised Code Section 2925.11, a Division B offense. Do you understand that charge?
Yes.
And do you wish to plead guilty to that charge?
Yes.
And forfeiture specification attached to it for contraband and instrumentalities, calling for your forfeiture of methamphetamine, a cigarette pack and packaging. Do you understand that?
Yes.
And do you wish to plead guilty to that?
Yes.
You understand if you plead guilty to the charges, you are admitting you committed the crimes.
Yes.
You understand if you had any defenses to the charges, you give up those defenses by pleading guilty.
Yes.
You understand by pleading guilty, you are giving the court the power to sentence you immediately.
Yes.
You understand any rulings previously made by this or any other court on any of these cases would not be appealable because you're pleading guilty now.
Yes.
And you understand that none of these crimes merge with each other. They're all separate offenses, and you're pleading guilty to all of them separately. I will find you guilty if I accept your plea on each of them and give you an appropriate sentence on each of them. Those sentences can be consecutive with one another. You understand that?
Yes.
And you understand what consecutive means?
Yes.
You have certain trial rights. You're giving them all up by pleading guilty. I'm going to explain them to you one at a time. I need to make sure that you know and understand you have these rights and that you're voluntarily giving up these rights. As I explain your rights to you, if you have any question about what I'm saying or if you need a better explanation, you need to speak up and let me know. Otherwise, I will assume you understood and answered the question that I asked you. Fair enough?
Yes.
You do not have to plead guilty. You have a right to have a trial to determine whether you're guilty of any crime. That trial would automatically be by a jury in this court unless you decided you wanted a non-jury trial. A non-jury trial is a trial where you want the judge not only to make all of the decisions throughout the case, but you want the judge to make the ultimate factual determination in the case whether the state can prove you're guilty beyond a reasonable doubt. Do you understand that?
Yes.
You understand that a trial gives you the ability to test every aspect of the state's case, both factual and legal.
Yes.
You understand that with the jury trial, the jury makes the decision, the judge does not, whether the state has proved its case against you. Furthermore, it takes all 12 jurors to agree that you're guilty before it's even possible for you to be convicted. Do you understand all of that?
Yes.
The state of Ohio is required to prove your guilt beyond a reasonable doubt. If the state failed to prove even one essential element of a particular charge beyond a reasonable doubt, you cannot be convicted of that particular crime. Your plea of guilty provides the court the entire factual and legal basis upon which to convict you and sentence you, and by your plea, you are relieving the state of any obligation to prove anything, let alone prove it beyond a reasonable doubt. Do you understand that?
Yes.
You have the right to confront your accusers, meaning to have your attorney question all of the state's witnesses under oath in front of the judge and jury. You understand that?
Yes.
You have the right to use the subpoena power of the court to compel witnesses you need to come here to testify for you, especially witnesses who are reluctant to come to court, out of state, or incarcerated someplace. I can get them here for you. You understand that?
Yes.
You have the right to tell your side of what occurred here and testify in your own defense. Or you could refuse to testify. It's one way or the other, but it is your choice. No one can compel you to testify if you did not want to, and if you chose not to testify, that could not be used against you to prove that you were guilty. In fact, the prosecutor could not even comment on your silence to infer you might be guilty of something to hide, maybe of a prior conviction. The jurors will be told you have the constitutional right not to take the stand and testify. We would select only individuals to serve as jurors. In your case, who answer under oath during jury selection, that they will uphold that right. Do you understand all of that?
Yes.
You understand that if you were not pleading guilty today, you would always be represented by an attorney at law throughout this case, free of charge to you if you could not afford counsel.
Yes.
You understand that if you were not pleading guilty today, you could appeal any of the decisions I would make throughout the case. You could appeal the jury's verdict. You would have a transcript typed up of everything that was said or done in this court, so you can demonstrate to a higher court any mistakes made here, to get those mistakes corrected, and an attorney to handle that appeal for you. And if you could no longer afford that, all of that would be provided to you free of charge, paid for by the taxpayers. Do you understand that?
Yes.
You understand a plea of guilty is a complete admission of guilt.
Yes. Yes.
Do you voluntarily give up all the rights that I just explained to you and wish to have this court accept your plea of guilty in the 1326 case, the lesser included offense to count 1, possession of heroin, felony 5, count 2, possession of cocaine, felony 5, in the 1286 case, count 1, possession of cocaine, felony 5, and in the 1403 case, count 1, aggravated possession of drugs, felony 5, and the forfeiture specifications attached to each.
Yes.
Are you now, or were you, at the time of any of these offenses, on parole, post-release control, community control sanctions, or probation to any court anywhere?
I was on probation.
Where?
In Cuyahoga.
Common pleas?
Yeah.
So when were you put on community control?
It was mid-21, mid-2021.
So before the very first one was committed?
Right after the first one was committed.
Right after the first one?
Yeah.
And were your crimes committed there before the crimes were committed on the first one here?
Yes, yes.
All
Not just the first ones were
Your Honor, maybe I could simplify this. He's aware that by pleading guilty, it will generate a probation violation in Cuyahoga County because some of, at least one of the crimes did post-date him being placed on probation in that county.
All right. And they know about this, right? Your PO knows about it?
Correct.
Yes.
All right. Has the judge taken any action yet?
No.
Probable cause hearing or anything?
No, I currently have a hold on in Cuyahoga for me.
Okay. So you understand by pleading guilty in these cases, you will conclusively establish for the Cuyahoga County Common Pleas Court that you violated a condition of community control, and it's a condition everywhere that you're obedient to the law.
Yes.
What's the crime of conviction there?
Possession of crack and heroin.
What level?
Felony 4. No, felony 5, sorry, felony 5.
Who's your judge there?
Santoli.
Have you ever been to prison before?
I have not.
Do you have any other felony convictions on your record other than the one we just talked about from Cuyahoga?
No.
So do you understand by pleading guilty, you are voluntarily giving up your freedom for whatever length of time I sentence you to prison, jail, or community control?
Correct. Yes.
And you understand that on each of these F5s, I can send you to prison for 12 months. If I did send you to prison, 6 months would be the minimum, and it would be a whole number of months between 6 and 12, and I can fine you up to $2,500.
Yes.
You understand that you would forfeit all items of contraband and instrumentalities mentioned.
Yes.
You understand that I can suspend your driver's license for up to 5 years.
Yes.
You understand that while in prison, if I did send you to prison, you may be eligible for, be offered, and be able to earn some credit against prison time to be served by engaging in educational, vocational, or rehabilitational programming offered to you for that purpose. The prison credit is normally capped at 8% of time to be served or a certain number of days according to their regulations.
Yeah.
Upon your release from prison, you could be on post-release control, PRC, in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. Do you understand?
Yes.
Under PRC, the Adult Parole Authority will give you rules. If you violate their rules, they can return you to prison for up to 9 months for any one violation, and subject to, for all violations in the aggregate, being returned to prison for up to 1/2 the original prison term I give you. All of that time is already part of the sentence. Do you understand that?
Yes.
Further, if your violation of PRC is a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on these cases for the greater of 1 year or whatever length of time remains unexpired on that potential 2 years of PRC, and all of that time is already part of the sentence. They don't have to bring the case back to this court in order to judicially impose additional time. You understand that?
Yes.
You understand that if I chose not to send you to prison, I would place you on community control sanctions, probation, for a period of up to 5 years.
Yes.
Under the community control sanction, you'd have to abide by all probationary conditions that I establish for you in the case, which would include time in the local jail, fine, license suspension, forfeiture, no contact order, abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, anything, any treatment for substance abuse or mental health issues, anything I determine you need to do. You understand you would be required to perform exactly what I tell you to do, exactly how I tell you to do it.
Yes.
If you fail to do so, you'd be brought back before me. On a probation violation, I will conduct a hearing. If I determine that you did violate your community control sanction, I can extend the period of time that you're on community control for up to that 5-year maximum. I can increase the nature and severity of the other conditions under the community control, meaning more time in jail, more treatment, more things to do. Or I can terminate community control altogether and just send you to prison for the maximum consecutive here.
Yes.
Now, when it comes to imposing a prison term, you understand that I can give you 12 months on each case, each count, and I can make those consecutive with one another for a total of 48 months in prison and total fines of up to $10,000.
Yes.
And you understand that and I will probably be sentencing you before the Cuyahoga County, because I think we will hold on to you until the sentencing and then send you to Cuyahoga on the holder. Or if I sent you to prison, Cuyahoga would have to go to the prison and pick you up there and bring you to their courthouse. But whoever sentences you last has the option of making that sentence consecutive to the sentence of the one who is handed down first. So if I give you prison and Cuyahoga County gives you prison, they can make theirs consecutive, or they can make their community control consecutive, so that when you get out of prison, then you go right back onto community control as adjusted based on the violation. You understand?
Yes.
That's how it works.
Yep.
And that if I did send you to prison, you're not serving community control time on Cuyahoga. That gets stayed while you're in prison, and it picks up again at the end.
Yes.
You understand that under both Ohio and federal law, you are disqualified from purchasing, owning, possessing, or using firearms or ammunition for firearms.
Yes.
Understand there are other disqualifications that accompany a conviction in this case. You cannot vote from prison. In order to regain your ability to vote, you'd have to re-register upon your release from prison. You understand that?
Yes.
You cannot serve as a juror while on community control, in prison, or on post-release control in any case in which the state of Ohio is a party, because in those statuses, your opponent in those cases would be the state of Ohio. You understand that?
Yes.
And you cannot hold any position of public honor or trust. You understand that?
Yes.
In addition to the fines and the forfeitures that I mentioned, you understand I will order you to reimburse the government the cost of confinement, supervision, any treatment, and court costs.
Yes.
And you understand the cost of confinement also includes transportation costs between the court, the jail, and the prison institution.
Yes.
You understand I will enter a judgment against you for the costs of prosecution.
Yes.
If you fail to pay that judgment or timely make payments on a payment plan approved by the court, and you are serving a community control sentence rather than a prison term, you may be able to substitute community service to work it off. By local rule, you'd work it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. You understand that?
Yes.
You understand a failure to pay all fines and costs in full can result in the state blocking your motor vehicle registration, your license plates, until they are paid in full.
Yes.
Do you understand all of the potential penalties?
Yes.
Do you have any question at all as to what can happen to you as a result of your plea of guilty today?
No.
You understand no promises have been made by the court, the prosecutor, your attorney, or anyone as to what I will do when it comes time for sentencing.
Yes.
You understand no one can promise you what I'll do because as I sit here, I don't even know what I'll do.
Yes.
Ms. Cotts, has the state of Ohio promised Mr. Ruvolo anything in these cases, and in particular with regard to sentencing?
No, Your Honor, the state has indicated that we would request a pre-sentence report and drug and alcohol evaluations, and no sentencing agreement has been reached.
And Mr. Ruvolo, did you hear and understand what the prosecutor said?
Yes.
And is what she said true?
Yes.
So the state has not promised you a community control recommendation, is that correct?
Correct.
Has anyone else made any promises or threats to you in order to get you to plead guilty?
No.
Ms. Cotts, on the two information charging documents, did Mr. Ruvolo receive any consideration there, or was he charged with the number and degree of charges that he could have been charged with?
Your Honor, in the bind-over case in 22 CR 1286, there were additional bind-over charges, mainly regarding traffic violations.
Any felonies?
Just regarding the actual cocaine. And the other matter, 22 CR 1403, is actually a secret, so the court does have a separate document to sign, so that he is booked in appropriately on that one. And this dealt with what he possessed on him drug-wise, so he is pulling to that as well.
Okay. So, Mr. Ruvolo, are you entering this plea freely and voluntarily?
Yes.
Have you told your attorney everything you considered important in these cases?
Yes.
Did you hold back anything from him?
No.
Have you had enough time to discuss what you're doing in these cases with your attorney?
Yes.
Although this may be your attorney's recommendation for you to plead guilty to these charges as you're doing, is this your own decision and voluntary act to do so?
Yes.
Has your attorney done everything you've asked him to do for you in these cases?
Yes.
And are you completely satisfied with the legal representation provided by Eric Norton, your attorney?
Yes.
Ms. Cotts, the basis for the recommendation on the first case and on all three cases, what would the facts show if they went to trial?
Your Honor, I would also like to, on the written plea of guilty and judgment entry on the 21 CR 1326 case, there is an error. Instead of having the revised code section 292511, which is correct for both of the counts, it does have the wrong section. I'm happy to correct that.
Oh, you have the 03.
That is correct, Your Honor.
Was he originally charged with trafficking?
No, he was not.
All right, I'll make those.
Strictly a typographical error on my part.
I'll make the changes.
Thank you.
We saw it. He'll initial change.
For the 21 CR 1326 case, the reduction is based on the court will have full knowledge of what occurred and will have the full ability to sentence as appropriate. In that matter, had that matter gone to trial, the state would have proven beyond a reasonable doubt that on March 3rd of 2021, around 5 p.m., officers were watching the Fairbridge Hotel in Wickliffe Lake County, Ohio. They were seeing various cars come and go, short-term traffic. That included a white Subaru that came up with a driver and passenger, both males. That vehicle, same vehicle was later seen to have, was observed to have equipment violations, a front windshield with a cracked the entire length obstructing the view. The traffic stop was conducted on 90 westbound near Euclid Avenue in Lake County, Ohio. The driver was identified as Thomas Coughlin. The passenger was Joseph Rivolo, the defendant in this case. There was various conversation with law enforcement, and then the defendant admitted that he had drugs on him, admitted purchasing heroin and crack cocaine, and having a cracked pipe in his boot. From his right front pants pocket, a baggie containing suspected heroin and a paper bindle containing suspected crack cocaine were removed. The pipe was later removed as well. Defendant was transported to the police department. The items were sent to the Lake County Crime Lab. Was confirmed to contain one item to contain heroin, a Schedule I controlled substance. The other two contained cocaine, a Schedule II controlled substance. The heroin did have a mixture with an isotonitazine, also a Schedule I controlled substance in it. All of this occurring in Lake County, Ohio, and that would have been the evidence regarding 21 CR 1326. Do you want me to continue with the other cases?
Yeah, go ahead.
In 22 CR 1286, the state would have proven beyond a reasonable doubt that on November 16th of 2021, about 11:50 p.m., Mentor Police Department officer was observing traffic, Mentor Avenue and Hopkins Road in Mentor, Lake County, Ohio, when they saw a white Subaru and ran the plates, finding that they had expired in May of 2021. A traffic stop was conducted in Mentor, Lake County, Ohio. The driver of that vehicle was Joseph Ruvolo, the defendant. There was a female front passenger, and the rear passenger was Thomas Coughlin. None of the individuals had valid licenses at that time. Officers saw Choroboy on the floor area. Inside the vehicle, next to the defendant's, where the defendant was seated, was a cigarette pack with folded paper containing suspected narcotics. Those were sent to the Lake County Crime Lab, and they were determined to be cocaine, a Schedule II controlled substance. There were also other items found in the vehicle, to include a pipe. There are multiple pipes, pills, tablets, capsules, as well as what they were packaged in. All this occurring in Lake County, Ohio, and that would have been the state's evidence on 22 CR 1286. In 22 CR 1403, had this matter gone to trial, the state would have proven beyond reasonable doubt that on November 16th of 2022, just after 10:30 a.m., Mentor Police Department officers were attempting to locate Joseph Ruvolo, the defendant, on outstanding warrants. They went to an address on Strumbly Place in Willoughby, Lake County, Ohio. Mr. Ruvolo had active warrants regarding the two prior cases I referred to. When officers were at that area, they eventually saw a male matching the description of Joseph Ruvolo in the driveway and garage area. They approached, identified him as Joseph Ruvolo. When he was arrested on the warrants, he was found to have on him a cigarette pack in his front right pocket, had a small bag with a crystal substance in it. That item was sent to the Lake County Crime Lab and was confirmed to be methamphetamine, a Schedule II controlled substance. The defendant had told law enforcement that it was in fact methamphetamine, all occurring in Lake County, Ohio, and that would have been the state's evidence in 22 CR 1403.
Mr. Ruvolo, did you hear and understand everything the prosecutor said as to all three cases?
Yes.
And is what she said true?
Yes.
So in the 1326 case, what is your plea to the lesser included offense to count 1, possession of heroin, felony 5?
Guilty.
The forfeiture specification?
Guilty.
Count 2, possession of cocaine, felony 5?
Guilty.
The forfeiture specification?
Guilty.
In the 1286 case, count 1, possession of cocaine, felony 5.
Guilty.
The forfeiture specification.
Guilty.
In the 1403 case, count 1, aggravated possession of drugs, felony 5.
Guilty.
And the forfeiture specification.
Guilty.
And hand you the written pleas of guilty documents, one for each case. Make sure you've read them, make sure you understand what they say, make sure you agree with what they say, and if you sign them only because that's what you want to do. Any markings I've made on those documents are in red, so you can easily tell what I've done to them since you last saw them.
Your Honor, I've received the written pleas of guilty and judgment entries in all three cases, 21 CR 1326, 22 CR 1286, 22 CR 1403, witness the defense denying a document in the state court is not to find in the matter.
The court will sign the judgment entry at the end of each document and make the written pleas of guilty part of the record in each case. The record should reflect that defendant Joseph A. Ruvolo was here with attorney Eric Norton in open court. I informed Mr. Ruvolo of all of his constitutional rights. He's made a knowing, intelligent, and voluntary waiver of those rights. I find he understands the nature of the charges, the effect of the pleas, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept his pleas and find him guilty. In the 1326 case, the lesser included offense is count 1, possession of heroin, felony 5. Count 2, possession of cocaine, felony 5. In the 1286 case, count 1, possession of cocaine, felony 5. In the 1403 case, count 1, aggravated possession of drugs, felony 5. All in violation of Revised Code 2925.11 and the forfeiture specifications attached to each. Count 3 on the 1326 case will be dismissed upon completion of sentencing. I'm going to refer the defendant to the Lake County Adult Probation Department for a pre-sentence investigation and report and a drug and alcohol evaluation with a brief mental assessment. Any other purposes for referral?
No, Your Honor, thank you. And Your Honor, I did have one request before we recess, but I didn't want to get ahead of myself.
All right, hold that thought.
Thank you, sir.
You still live at 38184 Strumbley Place in Willoughby?
Yes.
And is there a land phone line there?
No.
And cell phone of someone close to you?
Yeah. I don't know, I don't know a cell phone number.
Yeah. Could, yes.
3397? And yours mother?
Yes.
That 8195 number, is that yours?
Yes.
And is Britt Newman going to be doing sentencing?
I believe so, yes.
440-856-6444?
That's correct.
And sentencing would be on Monday, February 13th, 2023 at 9:15 a.m. And what is it that you wanted to address?
Thank you, Judge. I know that midway through the plea agreement, you had indicated a preference to keep the defendant remanded until sentencing. I was been talking to the family and to the defendant and to Ms. Newman as well. We believe, especially since he's been away from drugs now for 50 days, he's not in any kind of acute withdrawal, and we were going to ask the court to consider releasing him on bond, understanding, of course, that there's the holder in Cuyahoga County. My next order of business, regardless of what the court decides, will be to file a motion with Judge Santoli asking to remove the holder. And, so that there's that possibility that whether you keep him here pending sentencing or you release him, that he won't just be remanded to Cuyahoga County. But the client is Medicaid eligible. He would be able to renew his Medicaid eligibility, immediately, and he's expressed interest in attending a Signature Health intensive outpatient treatment program. I imagine that program, if he successfully completes it or is successfully participating in it, could go a long way towards him receiving community control sanctions. Thank you.
Your response?
Your Honor, we would oppose, well, first of all, there is bond in two of the cases. One of them is a secret, so that has not been set. So he's just not posted bond. It's not that there isn't a bond. However, especially on the 21 CR 1326, that bond was made higher because the defendant was gone for almost a year out on a warrant. And the reason that 22 CR 1286 actually occurred in 2021 is because while this case was still at the municipal court before it was bound over, he failed to appear and was gone for a year, that same time frame. Mm-hmm. So he was gone from the court from approximately November of 2021 to November of 2022. And while he was out, whatever he was doing, when he was finally arrested on those warrants, he had drugs on him. So at this point, we feel that it would be premature to release him, to have him go into an IOP. We have asked for a drug and alcohol evaluation, which the court has ordered. He does have that folder in Cuyahoga also for drug charges that he was on probation for. And we feel that at this point, Lake County should maintain him here so that we can complete our cases when he has shown a history of not returning to court, both for Lake County Court of Common Pleas and also for Mentor Municipal Court. He failed to appear in both of those locations. His history of drug charges at least goes back to 2003. Mentor Municipal Court, he had a possession of cocaine reduced to an attempted possession. And then in 2018, in Willoughby Municipal Court, a possession of drugs or 5 reduced to attempted possession of cocaine. And then we have March of 2021, November of 2021, and November of 2022. So based on that, we would ask that, I'm presuming the request is for an OR bond, that he not be given an OR bond, that he continue the 2 bonds that he has, and then the court make an appropriate bond on the 3rd case if the court keeps bond in place.
Your Honor, just to briefly respond on one point, he did not appear for the court for court on the matter of the City of Wickliffe case, the Willoughby Municipal Court case, possession of heroin, because he had entered a treatment program through CATS, Community Alternative Treatment, in Cuyahoga County. He was in it for a full 90 days, and that was obviously it was because of addiction to heroin. It was a very serious drug, and despite his record, he has kicked that particular habit. And I believe he's able to abstain from drug use.
When did he complete CATS?
Mid-2021.
Yeah, I believe July 2nd of 21.
But some of these crimes occurred after that.
The Mentor one, yes, and the one that picked up my warrant.
Okay. Then there's something going on, and I need to have a handle on it. Failing to appear is a major problem. In the 1326 case, the bond is continued at $25,000, cash surety 10%. In the 1286 case, bond is continued at $5,000, cash surety 10%. And in the 1403 case, bond is set at $10,000, cash surety 10%. And the defendant is to be processed by the Lake County Sheriff's Office on that charge because he hasn't been processed yet.
Right, the court has the document to sign,
I've signed
so
it.
that they know to
Right.
do that.
Is there anything further?
just ask if the court is requesting that the state complete the judgment entries on these matters.
Right. Prosecutor prepared draft entries. Anything further?
No, Your Honor, thank you very much.
I won't be here, so some other judge will sentence you on the 13th of February. Good luck. Now, the sentencing occurred more than 2 years ago. The defendant was given, 2 years of community control, if I recall, 60 days in jail.
Yes, Your Honor.
He served the 60 days. The holder was on him by ICE. Then he was deported. The 2 years is up. Then the Court of Appeals issued its decision on a 2-to-1 basis. And the two big things are, well, is the state asking for reconsideration or appealing?
I do not know the answer to that.
Okay. Well, the period for reconsideration, that's expired.
For reconsideration, yes.
Okay, but appeal, you have another 2 weeks? Isn't it 45 days? An appeal to the Supreme Court. And this was issued December 12th, 2022.
Yes, there would be more time, but I do not know the answer to that.
Okay, so the timing on this has created a lot of problems. The decision itself has created a lot of problems. The defendant has served his sentence. Just looking at it from a practical matter, if the plea were withdrawn, he'd go to trial on all the original charges, right?
If it were withdrawn, yes, I believe so.
Okay.
Yes.
Another consideration is, what are trial judges to do? Do we practice in the United States Code annotated that we have to look up their numbering system that is very foreign to Ohio's? And do we have to practice law and make a determination instead of having counsel and the defendant making the determination as to deportability? I'm not sure where this leaves trial courts in this state. Obviously, I disagree with the decision, and so does the dissent. And I have Ohio law in front of me. The statute says that a judge is supposed to say this, and I said this.
Well, a repentant is not.
Ms. Christ?
That is not that the requirement is on the judge, it is on the defendant's counsel to understand the full scope of the potential consequences of his plea. That the court is bound by the Ohio rules and, Criminal Rule 11 and, the requirements, but counsel has additional requirements to provide adequate representation.
Well, was this reversed for ineffective assistance of counsel?
Yes, that is the issue that we brought up on appeal, and that is what it was reversed over.
My understanding, Your Honor, was that it was brought back for a hearing on the motion to withdraw the plea, and that the court was to hear whether or not there was a denial of effective assistance of counsel, as was stated in that motion to withdraw the plea. And if I may, Your Honor, my reading of the opinion, it seems to state first that the conviction in the 2020 case for aggravated trafficking in drugs is a mandatory deportation, and that this triggered that duty in his attorneys at that time to inform him of such.
Correct.
One of the matters that the state would like to flesh out and is looking into is the merits of that, whether that is true,
and what in fact the defendant was deported for. In addition to his aggravated trafficking of drugs case and the other felony that he pled to, there was a third case. It was a Fairport Harbor case that was found back. And I emailed Mr. Curdy's attorneys yesterday about signing up for our e-discovery so I can provide them with other things in this Fairport Harbor case as well, because in there it is noted that ICE has been contacted and that if they were going to deport him, they would put a holder on him. Allison Hibbard, the attorney who signed the affidavit on the motion to withdraw the plea, was the attorney in that Fairport Harbor case. Additionally, of course, Mr. Curdy would have had that Fairport Harbor police report with that noted. And I believe that is of great importance here because in addition to whether the aggravated trafficking of drugs is what he was deported on, more importantly, whether that's a mandatory deportation charge, the defendant's knowledge is key here. And I believe that that police report, that information, as well as discussions that his attorneys, Allison Hibbard and Bethany Stewart, had with him, and due to the age of this case, also the notes that they may have taken about discussions with him and any discussions that an immigration attorney may have had with him would all be important in hearing. And so I spoke to public defender's office and I've spoken to Ms. Hibbard, and I don't know who the immigration attorney that is referenced is, and I don't know if his attorneys would be willing to disclose that information. I think that that would be important as well, because otherwise we're just allowing the hearsay that he's saying what the immigration attorney
Well,
but
yeah, you're correct. Number one, was he deported exactly for this plea? And number two, what information did he have? And to the extent that he's claiming ineffective assistance of counsel, he impliedly waives privilege.
Your Honor, I did not know if it was implied with the plea, and I think that was one of the things I hope to address today, to put it explicitly on the record that Mr. Curdy waived that privilege. The state would like to subpoena the attorney's files and ask that if it please the court, a process be allowed if the attorneys could give the files to you, Your Honor, and you would then provide to the state and Mr. Curdy's attorney, the attorneys, the information that's relevant to this issue that he has waived privilege to.
Well, right. It wouldn't waive privilege to everything. It would waive it only to this issue of naturalization, residency, deportation. So, but anything related to that would have to be waived. Counsel disagree with that?
No. I mean, we spoke about this yesterday. I think we're in agreement here that the state wants more time to flesh it out. We wouldn't object to that. And that anything, I mean, obviously if we're claiming ineffective assistance of counsel, that it does waive that privilege. So I think we had discussed about the in-camera review. So we're fine with that.
So do you know the names of all the attorneys that Mr. Curdy consulted with?
I do not know any of the names of the immigration attorneys that he would have consulted with. I know that Bethany Stewart from our Lake County Public Defender's Office represented him on the 2020 case, and Allison Hibbard represented him in the 2019 possession case and in the Fairport Harbor OBI case that was found back in Painesville Municipal Court.
Okay.
Your Honor?
Yes.
Sorry, I was the immigration attorney that represented him in immigration court.
Okay. When did you start representing him?
After he had already pled guilty to the charges.
Okay.
So February of 2021.
And Mr. Curdy, did you speak
Or
with...
February 2022, I'm sorry.
What are the names of all the attorneys that you consulted with before entering or at the time of entering your plea?
It's Bethany Stewart, the public defender from Lake County, and then we hired, for the 2019 case, we hired Allison Hubbard or Hubbard for the possession charge.
Okay, so only Bethany Stewart and Allison Hibbard?
Yes.
Okay, you didn't consult with any other attorney? You didn't consult with an attorney experienced in immigration?
No.
Or federal law? No?
Your Honor, he also had a Cuyahoga County Court of Common Pleas case. That would have been around this time. In fact, he was brought from the Cuyahoga County Jail to our jail to resolve his cases. So any conversations there, presumably, those were drug charges as well, would pertain to his knowledge of the deportability of convictions.
So he had 2 cases in this court, one in Painesville Municipal Court and one in Cuyahoga County Common Pleas Court, all going on around the same time?
Yes, at least, I believe it was just one in Cuyahoga County. If I may have a moment, I will find the details of that.
Okay. I wouldn't have known about those at the time I took his plea. I wouldn't have known any of that at the time I took his plea. The pre-sentence is done after I take the plea. So I don't recall having knowledge that there were any other cases pending at the time that I was doing the plea colloquy.
Your Honor?
Yes.
It wasn't pending. You got, Lake County came and picked me up for free. So I was already sentenced in Cuyahoga County when I came to Lake County.
In which county you were already sentenced?
In Lake County, in Cleveland.
That's Cuyahoga County.
I was already sentenced and they sent me to rehab, and Lake County came and picked me up from rehab.
Okay, so the case wasn't pending.
Yeah, I was already sentenced.
You were already sentenced. Okay.
Yeah, and they gave me rehab, and then Lake County came and picked me up like 30 days after.
Were you deported because of that case?
No. They literally released me from jail, and I went to CATS. CATS is not, it's not even a lockdown, just like I did like 6 months in that jail. They gave me CATS to go to CATS, and then when I was in CATS, like,
when did ICE put the holder on you?
No, they put it on me after I was guilty in your courtroom. After 3-4 days, I asked one of the CEOs in the jail, and he was like, yes, you got a holder from ICE.
Well, no, I knew about the holder at the time I took your plea.
Right.
So when did ICE put the holder on you?
Right when I came to Lake County, because I got released in Cuyahoga County. They gave me my property and everything. They took me to CATS, and as I don't know if you know, CATS is not a lockdown facility. I could have walked out the door, but I was literally trying to get help. You see, all my cases are all together. At that point, I was smoking meth, and I was just running, like, acting a fool, and that's all I have.
Your Honor, if I may just explain the procedural process with respect to the immigration case.
Okay, yeah, I'm a state judge. I don't know anything. I don't know anything about this.
Yeah,
so to the extent that a higher court is telling me I got to be an expert in immigration law, that's for the next seminar.
Okay, no problem. So the ICE detainer was placed on him in September of 2020. And then once that happened, he was then placed into removal proceeding, which is a whole other court process he has to go through, or he has a right to go through to challenge his deportation. And then I began representing him shortly after that in 2021. which is when his immigration case started. The trafficking conviction is considered an aggravated felony for purposes of immigration law, and those have the most severe immigration consequences, which essentially result in mandatory deportation. There's not much you can do to fight it other than requesting protection under the Convention Against Torture. So at the time I was representing him, he had already pled guilty to the drug trafficking conviction. He had an aggravated felony. He was only able to request protection under this international doctrine. And then after the judge's decision in that case is when there was technically a removal order issued. And that would have been what triggered his actual deportation.
So when was he charged in the case that I handled, this case?
This case, it was September of 2020. So he was charged in September 2020, and that's when the ICE hold was placed.
Is that when they arrested him?
I believe so.
Was this a buy-bust? Was this a buy-bust?
The 2020 case, yes.
My case, this case.
Yes. If I may, Your Honor, the incident that resulted in the possession of cocaine felony here happened in September of 2019. The Fairport Harbor OVI, that was a bind back, that in the police report states that the police are contacting ICE, and an ICE representative responds that if they decide to deport him, a holder will be placed on him. That occurred in October of 2019. The incident of aggravated trafficking of drugs happened in January of 2020. Cuyahoga County incident happened in February of 2020, and it is unclear what triggered the ICE holder. It could be none of these things. We don't know. But to say that he has a conviction here, which is essentially a deportable offense, that does not mean that is why he was deported. That does not mean that is why the holder was there. He was not convicted when a holder was in place for him. And we don't know what information he had been receiving about ICE and deportation from Cuyahoga County, from other attorneys, and from the attorneys in this case.
If we want more time to investigate, that's fine. Or just that an ICE hold, that in and of itself is a pretty standard procedure when a non-citizen is arrested. That doesn't mean that they're going to be deported. It's really just a standard practice. That's not an indication of deportable or not.
Let me sort of skip to the chase here. Let's assume, jumping over a million legal questions and hurdles, let's assume I grant Mr. Curdy a new trial. Does ICE go over there, get him, bring him over here to stand trial? Do they welcome him back and say, never mind the deportation? I mean, practically, what happens?
Your Honor, if the conviction were technically vacated and he was able to get a new trial, he would be able to return to the United States and reopen his immigration case and have options that were not available to him previously. He had a green card at the time he was arrested, so he had certain options available to him that aren't available to a undocumented person but for the conviction for aggravated trafficking, he would have been eligible for.
And then if he's convicted, what happens?
If he's convicted of the aggravated trafficking?
Well, no. What's the original charge? What's the top charge? Wasn't it an F3?
That's what he was convicted of, was the F3 aggravated trafficking.
Is that the top charge?
Yes, Your Honor, I believe this pled by way of information.
Oh, it was information.
I'm not familiar with what other charges could have been there at this
Okay,
time.
but if he goes to trial, he doesn't go to trial on an information, he goes to trial on an indictment. The information's a plea bargain. There's no plea bargain if he's not going to plead. So you'd have to take it to the grand jury for indictment. And then he would go to trial on whatever's indicted. But you don't go to trial on an information. Right? Have you ever known
Yes, Your
anyone?
Honor, we would not go to
I've never heard of anyone going to trial on an information in the state of Ohio. You have a right to a grand jury indictment and a trial after that. And the state wouldn't be in the mood of making deals at that point. Correct?
Correct, Your Honor, if we got to that point.
Okay. So then what happened about the 60 days in jail and the 2 years of community control? Although he didn't serve community control for 2 years. When did he actually get deported?
He was deported last year in May of 2020.
May 9th.
May 19th of 22?
Yes, I got to Georgia May 20th. Because there's a 7-hour difference.
Okay, so,
So, again, I believe that this was, I think we're in agreement here. The fact that there was a holder, it could mean many things. And what he in fact was deported for, we don't know at this time. The state is looking to see if it can obtain some type of record. If counsel here was the attorney, perhaps they have that record if some motion to compel is necessary. But perhaps the state would file one of those. Again, to determine this issue of whether this is indeed an offense that results in mandatory removal.
It does.
And further, whether the defendant had knowledge of what the consequences were, what he understood the ICE folder to mean, what he understood. I believe counsel would probably like to see the Fairport Harbor Police report and what he understood that to mean. I just sent the transcripts yesterday where the defendant is acknowledging an ICE folder at his change of plea, not after sentencing. So there was some discussion at the change of plea. According to Ms. Hibbert's affidavit, I believe she says it happens after. She's present for the change of plea when you ask him if he knew about the ICE folder, and he says yes. So I believe there's more information that needs to be.
well, but there is another step. And then, would you have entered the plea if you knew that you were going to be deported? And if you say no, then you go to trial the next week or 2 weeks later, and you may get the exact same result from a jury, and then you're still deported. Right?
Right.
I mean, so what's the evidence against him here? Is this an eyewitness identification from 40 feet away in the dark? Or is this a police officer right up there? I mean, I can't remember. This wasn't tried.
For the facts of our case.
Well, for the trafficking, whatever, yeah.
Your Honor, in every case I do recall, he makes admissions and he does state that he would cooperate with narcotics and other law enforcement and then does not follow through with that. The extent of those admissions, I don't recall this.
Okay. So, I think we have to take it a step at a time and wait for the state to decide whether they are going to appeal. And if they don't appeal, then I'd have to give you time to conduct discovery on the issue of what the defendant knew or did not know. What did the attorneys know or did not know prior to Mr. Curdy entering the plea, right?
Yes, Your Honor, in order to do that, since we are on the record, I would ask that we place something on the record with Mr. Curdy waiving explicitly the attorney-client privilege as to that matter, and that's something we place on the record that it was done with the advice of counsel that we had discussions about that.
Right. Mr. Curdy, you've been following the discussion that we've had about attorney-client privilege.
Yeah, but I didn't get it. Like, I didn't understand.
All right, let me explain it.
Okay.
When you consult with an attorney, just you and the attorney, anything you talk about is privilege, meaning that the attorney can be prohibited from talking about anything that was discussed within that attorney-client confidential conversation, so long as there's no provision of law that requires disclosure. You know, like somebody says, I'm going to go kill somebody, that gets disclosed. When you raise the issue on appeal of ineffective assistance of counsel, meaning that your attorney did not perform as a reasonably competent attorney in not advising you that it was guaranteed 100% you will be deported if you plead guilty to this felony 3 in my court, then you are impliedly waiving privilege on that, because the state has the right to test that, right. And if you want a hearing on it, you're going to have to testify about what your attorney did or did not say to you. So in order to give counsel time to prepare for a hearing on a request to withdraw your plea, if we get to that point, then we need to have on the record that you wish to pursue that and that you are waiving privilege as to that issue. Now, that doesn't mean that you're waiving issue to, any other trial strategy, medical matters, things of that sort. It would only be as to the issue of the consequences, the collateral consequence of your pleading to this particular crime in this particular case. And in order to assure that the prosecutor isn't getting more information than to which it's entitled by the waiver of attorney-client privilege, the judge would be the gatekeeper and look at those communications and only divulge to the state's attorney that conversation dealing with deportation, removal, federal law, immigration law, as it pertains to your immigration status. Does that clarify it?
Yes, a little bit, yes. I think I got it.
Do you have any questions for your attorneys? You have immigration attorney here, you have the attorney, well, and both of them were the attorneys on the appeal. Do you have any questions for them?
No, I do not. Thank you.
All right, so do you waive attorney-client privilege with regard to the issue of whatever conversation or advice or discussion was had regarding the collateral consequence of immigration status, removal status, things of that sort? It would only be as to the issue of the consequences of your pleading to this particular crime in this particular case. And in order to assure that the prosecutor isn't getting more information than to which it's entitled by the waiver of attorney-client privilege, the judge would be the gatekeeper and look at those communications and only divulge to the state's attorney that conversation dealing with federal law, immigration law, as it pertains to your immigration status. Does that clarify it?
Yes, a little bit, yes. I think I got it.
on your plea in this case?
And then if I say no, you're gonna be the...
Well, if you say you're not waiving privilege, then it's an easier decision for the judge to deny, because we'd only be guessing what the attorney told you or didn't tell you.
Oh, my bad. Now I got it. Okay. So basically, I'm giving a privilege for the state or for my attorneys to basically ask my attorneys what happened, what type of discussions happened between them, right?
Right. It would include anything in writing in their notes, and it would include questioning the attorneys as to what was said or what was not said. Okay. It works both ways. But if you don't waive privilege, then the judge is not going to guess what was said or not said. It would just be denial.
Right. Yeah, now I got the big picture. I'm sorry. You know.
So just so there's a clear question and answer, do you waive attorney-client privilege for matters relevant to the issue before the court?
Yes, Your Honor.
All right. And Ms. Christ and Ms. Lagasse, do you concur with that and agree that privilege should be waived in order to hear this?
Yes, Your Honor. Yes, Your Honor.
All right. So, Mr. Curdy, if you didn't hear, both attorneys said that they also agreed that the attorney-client privilege should be waived. And I do have the boss of one of the attorneys at the time here, Vanessa Clapp, the public defender. Ms. Clapp, do you agree that, and these attorneys are not with your, or Bethany is no longer with your office, but you have custody of the file, and it's in your possession. Do you agree that privilege should be waived as to the relevant issue here, and that the procedure that I outlined, an in-camera inspection first, would be adequate to safeguard your former client's attorney-client privilege? Okay. What else needs to be discussed at this stage?
I don't believe there's anything else at this stage, Your Honor.
Okay. Ms. Christ, Ms. Lagasse?
Nothing on our end unless we wanted to set out a schedule, if we want to set a schedule for a secondary hearing, or if we wanted to wait until the hearing was conducted.
I think we need to cross the threshold of the jurisdictional issue of appeal by the state, and I can tell you I won't be hearing the case. My successor will be hearing this, because I wouldn't start this because I can't complete it. So, Mr. Curdy, the governor of Ohio will appoint a replacement judge for me. Whoever that replacement is will handle your case, unless it's a member of the prosecutor's office, in which case it would probably be given to another judge. Even though one of the candidates is in the civil division, I don't know. It might be a matter of avoiding the appearance of impropriety at that point. But I'll leave that for you folks to raise at the particular time. Ms. Zagreski, anything else?
No, Your Honor, thank you.
Ms. Crisp, Ms. Lagasse, anything else?
No, Your Honor.
Ms. Clapp, anything? Probation Department. I mean, as far as you were concerned, he was done. Well, up to the point where he left the country against his will. All right. And Mr. Curdy, do you have anything else? Any questions? Any? Was that a no?
Yeah, I said no, thank you. I appreciate it.
Okay. All right. We'll be adjourned, and Is it possible to ask for both to do suspending until after that you're out?
All rise. Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presiding.
May be seated. On the record, this is case number 22CR000157, State of Ohio versus Devin Jonathan Levitt Bullen. Mr. Bolin is in court, represented by counsel. Attorney Brendan Keating, representing the state of Ohio, is Assistant Prosecuting Attorney Rachel Wood. The defendant was here on October 19th, 2022. He pled guilty to count 2, possession of a fentanyl-related compound, felony 1, with mandatory prison, and a forfeiture specification for contraband and instrumentalities, and 1 for proceeds in the amount of $615. I referred him for a pre-sentence investigation and report and set sentencing. I continued his bond. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated November 29th, 2022. I've received a drug and alcohol evaluation with a brief mental assessment prepared by Dr. Rinsberg dated December 13th, 2022. I've received a letter from David Ellis in support of the defendant. I have read these documents. I will make them part of the record. The pre-sentence report also shows that the jail credit as of today is 32 days. Is that accurate?
Yes, Your Honor.
Yes, Your Honor.
All right. Ms. Keating, any reason not to proceed to sentencing?
No, Your Honor.
And any adjustments needed to the PSR?
Not that I saw, Your Honor.
All right, you may address the court first.
Thank you, Your Honor. May it please the court, Ms. Wood, and all friends and family of Devin. Your Honor, obviously, this is the end of maybe some behavior on Devin's part. That night, when he was pulled over, stopped, and arrested, he told me, and maybe this is because he's been working with people who are now helping him, but he told me when I got pulled over and I knew that this gig was up, a sense of relief came over me. I don't know, can't tell you how many times I've heard the defendant tell me that. I don't think I've ever heard that. But that's what he said, and that's what he expressed to me, and I believe him. He said, I was just glad it was all over. And the police report, Your Honor, also shows that upon arrest, maybe Devin did a few things that person who knew he was in some serious trouble might have done. I'm not excusing it, but that didn't last long, that ruse of him maybe throwing something out of the car. And from that point forward, my client was cooperative, and I believe, Your Honor, that's indicated in the police report. And I think that's indicative of whether after Devin serves his prison term, that this is going to stop and the public is going to be protected. He has insight into the criminality of what occurred. Since that arrest, he has been working with, I know, a gentleman back there, Pastor Chuck Gantz, who the court will allow, would like to address the court. But Pastor Chuck has been calling, he's been just bullish on Devin and how much he thinks of him. And I think also if you look into the gallery, you'll see everybody else who is here in support of him. Not everybody has that. And again, I think that that's something that the court can take and look into the future and take a chance on Devin and say that perhaps this young man, that this is it, that the public will be protected, he's going to be punished, but in this case, we'll take a chance. And for those reasons, what he's told me, everybody here, my interaction with him, I
I think that in this case, the minimum sentence would adequately protect the public, but also punish Devin. Obviously, he doesn't want to go to prison, but he knows that he's going to have to accept his punishment. And it's my hope on his behalf that he has learned that this will end. Fentanyl is a scourge in all of these communities, and I know the court takes it seriously. It has to stop. And hopefully Devin realizes that he doesn't want to be a part of anything that's addicting people, killing people left and right in our communities. And I just impart that maybe upon him more than anybody. Devin, would you like to address the court?
Yes. I've been fortunate enough to have been allowed from jail on bond to go to treatment and recovery housing. I'm a firm believer that everything happens for a reason. I'm able to look back on my arrest date and be grateful that God blessed me with another chance. The sense of relief I felt in the back of the cop car was overwhelming, knowing that I didn't have to live in that insanity anymore, and although I had consequences and weeks of withdrawal ahead of me, I knew it was a blessing. It's been an awesome journey from that day to now. I've met a lot of people who have helped me in my recovery and that God has used to plant a message in me. Through strengthening a relationship with Him, I've been able to work a successful program. Many relationships I thought I'd never get back, form new healthy relationships, be able to be clear-headed and in a good headspace, speak at treatment centers in hopes to deliver a message of experience, strength, and hope, lead by example in different areas, most importantly with how I've dealt with this situation, and the list goes on. As I said, I'm a firm believer that everything happens for a reason, and through this experience, my family's spirituality has been reignited through mine, and that alone has made this whole thing worthwhile in my eyes. I accept all responsibilities for my actions, and whatever punishment I aim to receive today, knowing that it will be a period of growth, that in the end, it will turn me into the man I've been raised to be and who God intended me to be. Thank you.
Your Honor, may it please the court, there are three people who would like to speak on Devin's behalf. They are Pastor Chuck Gantz, Mr. Regis Shudik, who's Devin's sponsor in recovery, and the defendant's mother, Tina Bull.
All right, let me have the pastor first.
Thank you, Your Honor, for giving us the opportunity to do this. My name is Pastor Chuck Gantz, and
Spell your last name.
I'm involved in...
Would you spell your last name?
Excuse me?
Would you spell your last name?
Sure. Gantz.
And you're a pastor?
I'm a pastor at Seeking God's Glory in Warren. I have two churches there. I'm also head of the Mahoney Valley Hope Center, which is for recidivism rate. We go into all the prisons in the state of Ohio. I've done that now for about 15 years, been a pastor for 23 years. Don't want to take much of your time. I know I'm a little emotional. I lost one of my best friends today. And now I'm standing before you speaking and trying to just take what Attorney Keating said and take it to another level by actually spending time with Devin. And I've had that opportunity for almost 11 months. And when he first came, and I know you hear this all the time, but when he came to the church, I had no idea that he was in any type of serious trouble like he was. I knew that he had the ankle bracelet on, and I knew that there was something going on. I knew he was coming out of a sober living home, and I knew that he was seeking help. And then when he sat down and he gave me the whole scenario of what had happened, that's when I got a hold of Attorney Keating, and I said, look, I'm going to invest in you, but you have to invest now in your life, spiritually, for your family, but mostly for yourself and the people that you could potentially hurt by what you have done. And he took that responsibility and held his head high, knowing that he was going to face what is happening here today. But the but factor in this whole thing is
I've never, and I mean this sincerely, I've never seen a young man take responsibility for what he has done, assuming that he's going to pay by going to prison. But I'm coming to you. I know it's a mandatory, and that word mandatory is what it is, mandatory. But I am asking, doing my due diligence for who I represent, and these people that have been praying for him for 11 months now, laying down the mercy right here and asking that if it's mandatory, that has to be taken. And he has to face that it would be the most leniency, because right now, and I'll just give you one scenario of one day that I'll be done, and I thank you again. One day last summer, we had a big event at our church, and young people were coming, young 8, 9, 10, 11-year-olds. And I had told Evan that, I said, you know, when this is all over, you've got a spirit to be a youth minister. And people might say that's, insane because of your past. Well, I know where I came from, and I know I've been doing for 20-some years now. But when I seen the way he conducted himself, and there was 3 or 4 pastors around said the same thing, that's your next youth pastor. Young men were grabbing onto him, and he wasn't trying to shy away from what was happening. He was using this example to these young men. And so I hope that paints a picture of, we're trying to talk to you about a young man and where he's gone and what he's done and where the future holds for him. But that's where I'm asking, if I can, if I'm allowed to do that, the leniency of the mandatory. And we all understand that. So I want to thank you so much, Your Honor, and I appreciate your time. And hopefully that gives you an idea of an example of someone that really wants to change their life and has already done that. So I thank you very much.
Okay, thank you. I'll call your next witness.
Yes, Your Honor, I'll call Regis Shudik.
Afternoon.
Good afternoon, Your Honor. My name is Regis Shudik, S-H-U-T-T-I-C.
And
Address?
R-E-G-I-S?
R-E-G-I-S.
I don't need your address.
Okay.
And your relationship with Devin?
I am his friend and his sponsor.
12-step sponsor?
Yes, sir.
Go ahead.
I've known him for some years now, and I remember when he first came in, some people you see that they've had enough pain, and we all can talk pretty well at times, but it wasn't through his words as much as it was his actions in the program. Going through the 12 steps. I do a lot of H&I, which is hospitals and institutions. We take it into jails and psych wards and other places, and I had the honor and the privilege to bring him in with me and just see the impact that he's had on people that are in treatment and try to be of service to people. I think his actions, like I said, speak a lot louder than what his words. I think when we reach that certain point of having enough pain, we're willing to do something different. Whether that was too little, too late in this situation with him already being charged, I don't know. But I know that the recovery community will definitely miss him not being around. I can't say that about very many people. That's all I have, Honor. Thank you.
Okay, thank you. And call your next witness.
Yes, Your Honor, I'll call Tina Bolin.
Your Honor, can I come up with my daughter to support?
Sure.
My name is Tina Bolin.
T-I-N-A?
Yes,
And your relationship with Devin?
his mother.
And what do you want me to know?
Hopefully I can make it through it. If not, I have my mom. Devin is a miracle. Each and every breath he takes is proof that miracles happen. proof that God exists, proof that life wins, and that love sustains. Devin's story is of hope and redemption, a brutal war he fought, a war that he should have taken his life, a war of good versus evil, of darkness versus light, of life versus death, a war that took place inside his head, a war that cost him his freedom, but it was a war that he won and gave him new life. This war has a name. It's called addiction. Millions of people fight this war every single day. It has claimed many lives and continues to take people out daily. It's sneaky. You don't know you're in it until it already has you. It lies and makes you think you are in control while it completely dominates you. It's a thief. It will rob everything you have and leave you with nothing. It is lethal. It won't stop until you are dead. The genetic odds were not in Devin's favor. However, Devin realized the battle is worth the winning, that his life matters. In the darkness days, in his most excruciating moments, God showed up and offered him life. My son is not a criminal. He is an addict. His actions of buying drugs to feed his addiction harmed only him, not others or the community. Devin's transformation has led him to serve his community, his church, and other addicts in recovery. Putting him in jail is stripping him from all his successes and the outreach he has been to others. The last time we were here, I told my son Devin he has never been a disappointment to me. I have always been proud of him and know his words will forever be true. Thank you, Your Honor.
Okay, thank you.
Your Honor, if I may please the court, I just one last word. Just be remiss. These people in the audience, especially Pastor Chuck, just tremendous faith, and they believe in miracles. And the miracle here would have been some form of probation. Well, wasn't in the cards. And there was a point in time when I had to tell Devin, there isn't going to be a miracle here. This is how it's going to be. And as far as I know, Your Honor, he hasn't violated his bond. He has remained off of drugs and alcohol, and he's also remained clean and sober and hasn't been a problem while out on bond. Since that day, I had to just flat out tell him it's not going to happen. This is how it's going to be. And he's accepted that, and he has still stayed on that track that he's been on since he was arrested. Thank you, Your Honor.
Okay. Let me hear from the state.
Thank you, Your Honor. On behalf of the state, this was an incident that began as a traffic stop, and as the defendant was pulling his vehicle over, drew out of his car window a baggie that contained an F1 amount of fentanyl as well as a scale. When he was asked to step out of the vehicle, he did attempt to kick the baggie of drugs underneath the vehicle in an attempt to evade the officer's detection. But after that, as Mr. Keating noted, he was very cooperative with the officers, with all the officers on scene, and he did accept responsibility by pleading guilty here. The defendant does have a history of criminal convictions dating back to 2017. He has received reductions on past cases, drug offenses. 2017, he has a conviction for attempted trafficking, and in 2018, a conviction for attempted possession of cocaine, as well as another misdemeanor conviction for possession of drugs. Based on the pre-sentence report, the defendant has not responded favorably to previously imposed sanctions. The pre-sentence report notes that he's been engaged in treatment in the past, but he continued to pick up new offenses. But I commend him now for the success that he has engaged in since this offense took place. The public needs to be protected from this. As was stated earlier, fentanyl, even in the tiniest amount, can be deadly, and this was 29 grams of fentanyl, and the defendant needs to be punished for his behavior. So the state is recommending 4 years with 32 days credit. The state would dismiss the remaining counts. We would ask that the items in the money be forfeited, as well as the mandatory fine be imposed unless the court finds that the defendant is indigent, as well as an advisement that PRC is mandatory in this case. Thank you.
Consider the record, the oral statements made, the pre-sentence report, drug and alcohol and psychological evaluations, my conference in chambers with counsel and probation, and the the many statements in support of the defendant here. I've considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden on governmental resources. I've considered these separate recommendations of the parties. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders, in using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code Section 2929.12. In that regard, there are no factors making the offense more serious except to the extent that the defendant attempted to tamper with the evidence, which could have formed the basis of another felony 3 charge that would make the crime itself a little more serious. In terms of factors making it less serious, the offender did not cause or expect to cause harm to person or property. The defendant is remorseful and has accepted responsibility and was cooperative with the officers after that. The seriousness of fentanyl is already taken into consideration in the level of the crime for which the defendant was convicted. In terms of recidivism, there are factors that make recidivism more likely. Defendant does have a previous criminal history, which primarily consists of 3 drug offenses, one in 2016, one in 2017, and one in 2018. And he's been through treatment, including the halfway house, the intensive outpatient treatment, and inpatient treatment. The defendant failed to respond in the past to probation, as evidenced by repeat offenses in drug offenses. There's a pattern of substance abuse, and the offender either refuses to acknowledge problem or accept treatment or apply treatment tools previously given to him. Those would make recidivism more likely. In terms of making recidivism less likely, defendant has no juvenile record that's come to the attention of the court. He's been law-abiding for a significant number of years or in other arenas other than being an addict, and is genuinely remorseful. His risk assessment score is 15, which is considered medium, but I consider that a factor making recidivism less likely because most of the people I send to prison have ORAS scores that are in the 20s and 30s. Prison is mandatory here by law, and the issue for me to determine is, what's the range? Is it 3 years? Is it 11 years? Well, the defendant's not been to prison before and has low-level crimes on his record, and they're drug offenses, and no crimes of violence or anything of that sort, and the court believes that the sentence should be at the minimum level. So I'm imposing an indefinite minimum term of 3 years and a maximum Senate Bill 201 of 4.5 years. The 4.5 comes from the 3 years, being half of the 3 years. The credit is 32 days. It'll forfeit all contraband, instrumentalities, and the proceeds in the amount of $615. There's a mandatory fine of $10,000. And what are your assets?
Yes, money, bank account, property, like $250, around every house.
Counsel, if you file a motion to relieve him of the mandatory fine on the basis of indigence, and if you file that, electronically, before I journalize this, then I will suspend the fine.
Thank you, Your Honor. I will do that.
You to pay the costs of confinement, prosecution, supervision, treatment, and court costs. Counts 1 and 3 through 8 are dismissed. Upon your release from prison, you'll be on a mandatory period of post-release control, PRC, for a minimum of 2 years up to a maximum of 5 years. The Adult Parole Authority will give you rules. If you violate their rules, they can return you to prison for up to 9 months for any one violation and up to 1.5 years for all violations in the aggregate. All of that time is part of the sentence. Should the violation of PRC be a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired on that mandatory 2 to 5 years of PRC, and all of that time is part of the credit. Is part of the sentence in this case. I talked about some credits that were under the law available, the 8% credit, the 5 to 15% credit. However, I explained them to you just so you know that they exist. You can inquire about them, but I do not believe that any of these credits can apply to this case because it is mandatory prison, and judicial release is not permitted, nor are the 8% or the 5 to 15% credits available. Your presumptive release date is at the completion of 3 years, but that presumption can be rebutted, and they can hold you for up to that 4.5 years. They can do it multiple times for reasonable periods of time based upon the criteria that I told you about when I took your plea. Institutional rule infractions, violations of law that compromise prison security or threaten safety of prison staff or inmates, being in a higher security residence level. All of those were set forth in the written plea agreement, so I'm not going to attempt to summarize them now, but they should be repeated in the entry. So long as you owe any court costs, the state can block your motor vehicle license plates, or if you owe any fines, until the fines and costs have been paid in full. You are already under a firearms disability, but I want to reiterate that because of the conviction in this case, you cannot purchase, own, possess, or use firearms or ammunition for firearms. In order to vote upon your release, you have to re-register, and you cannot hold any position of public honor or trust. Bond, if any, is released. I think you're wearing an ankle bracelet as part of bond, right?
Yes.
They'll take that off. Anything further from the state?
No, Your
Defense?
No, Your Honor.
Anything from probation? All right. Your attorney talked about miracles, and the miracle I'm interested in is that you improve your life when you get out. I've had many people, despite being sent to prison, have thanked me for doing that, and it's always gratifying to know that prison isn't just a place where people go to get worse off, because that's what most people think. That's what I think. But you can show the miracle and get your head on straight. You're headed in that path already, obviously, from the people that spoke on your behalf. So that's the miracle that I'm interested in seeing. I wish you the best of luck.
Thank you. Thank you.
and circulated.
So he went to Siberia. He went to Siberia about his, that was after, I'm not sure. Says May.
We're on the record, this is case number 21 CR 000867 and case number 22 CR 000972. Both cases, State of Ohio versus Ronald J. Samueli. Mr. Samueli is in court, represented by counsel. Attorney Richard Perez, representing the State of Ohio, is Assistant Prosecuting Attorney Brian Kerfoot. On the 21 case, Mr. Samueli was here with counsel. On February 14th, 2022, different defense counsel. I aborted the hearing and revoked bond because the defendant ingested fentanyl that morning. I rescheduled the matter for March 7th, 2022. The defendant was back in court with counsel. He had requested intervention in lieu of conviction. I had him assessed by an appropriately licensed professional. I determined he was eligible for intervention. I had reason to believe that substance usage was a factor leading to his criminal behavior, that intervention would not demean the offense. Intervention would likely reduce future criminal activity. The defendant told me he was willing to comply with the order of the court for intervention, the intervention plan. I granted it on that basis. I stayed all criminal proceedings. I reinstated his bond until completion of the intervention. He pled guilty to count 1, possession of a fentanyl-related compound, felony 5, a Division B offense. I ordered him to comply with an intervention plan, which included 2 years of community control monitoring, 23 days in jail, credit for 22 days. He was to be released by noon on March 8th, 2022, to enter, participate in, and successfully complete a 30-day residential treatment program, intensive outpatient treatment program at Meridian Healthcare Facility in Youngstown at the defendant's expense, and follow all recommendations and aftercare. I ordered that he could be transported by his mother, Leanne Takla. Meridian was to test the defendant and report all results to the Lake County Adult Probation Department. The defendant was to evaluate and consider the opiate recovery program and follow all recommendations and aftercare if he went with the injections, complete abstinence from alcohol and drugs of abuse, periodic screens to monitor his compliance. I ordered him to engage in 3 12-step program meetings per week, have a sponsor, and be involved in a home group. He was to have full-time employment or school or combination of employment and school, but outside of any establishments that sell or purvey alcohol or drugs as the primary source of revenue. He was to forfeit all contraband and instrumentalities. He was to have one doctor, one dentist, one pharmacy at any one time in any one specialty, prescribing or filling prescriptions for him. He was to inform the adult probation department of any change in providers and sign medical releases so that they can monitor drug-seeking activity on his part and inform his providers of his addiction. He was to take all medicines as prescribed, have a mental health assessment, and follow all recommendations. He was to pay the costs of confinement, prosecution, supervision, treatment, and court costs. So I mapped out a very careful plan for him to follow. I told him a violation would result in a termination of intervention, a finding of guilty on the charge to which he pled guilty, possession of a fentanyl-related compound, felony 5, and an appropriate felony sentence, which would be 6, 7, 8, 9, 10, 11, or 12 months in prison. I notified him of the potential and consequences for violation of post-release control. And that's the last note that I have in my notes. So the defendant is here on several violations of that intervention plan. Kaylee, how many violations are here? I have like a lot of pages of, how many violations are here?
So, the first violation warrant was issued on March 2022 for April 11. That was for failing to enter a prison on the day that he was sentenced to. We did investigate him as bond, and the Meridian, and he was up successfully. There was an addendum filed on May 18th of 2022 for two violations. A second violation was filed with a new warrant on May 25th. For 8, there was an addendum on June 8th of 2022 for 203, and an addendum filed December 12th of 2022 for 1 with the lower 48. So there's
So, what's the date that the first one affidavit was done?
March 8th.
I'm looking for something dated March 8th, and I'm not finding it.
I have a copy of the affidavit, Your Honor.
How many affidavits are there total? 5?
Correct, 5 affidavits.
Okay, give them to me. My file is just not organized whatsoever. I have no idea what I'm looking at here. Let me have it. Yeah.
Your Honor, could I have an opportunity to look at those for a minute also, after you look at them?
Sure.
Thank you, Your Honor. You want these back, Judge?
Yes.
May I put your on?
Yes. All right, so what I have here is a series of probation violations on my order. And you got to bear with me. I never get this many violations on an order for intervention because most people are compliant with that because they know they're not going to get a conviction. This is why this is throwing me for a loop because I've never seen anything like this. But I've only been here 23 years. And, I guess there's something new every day. But the first violation is a violation of Rule 11, which says you shall comply with all conditions set by the court. The defendant failed to enter treatment at Meridian Healthcare in Youngstown, Ohio on March 8, 2022. I'm not sure how that can be because I sent you right from here to there with your mother. That's the first violation alleged, March 8, 2022. Now, I don't know, you might have ended up there, but this says you didn't.
You may recall, Judge, that was a problem with prior counsel who indicated that he had a bed there. She did not confirm that he had a bed there. Mom had discussed...
So she lied to me.
Yeah,
she lied to me.
Correct.
Just outright lied.
Right. So that was later withdrawn, I believe, that violation, but he did end up going there and completing the program, correct?
Correct.
So that was an issue that I don't believe was his fault, and I think you acknowledged that at some point.
And that is the state's understanding as well.
Okay.
That violation was the product of prior counsel. If the state did not seek a withdrawal, the state would be seeking a withdrawal.
All right. So this one is being withdrawn.
The March 8th, it would be withdrawn.
Okay. And you got to help me out with the memory because I can't remember every case or the details of every case. All right, the next one that I have, the affidavit is dated May 18th, 2022. Rule 3 requires reporting. It says the defendant failed to report as directed on May 9th, May 10th, May 17th, 2022, and has made no attempts to contact this officer. You familiar with that charge?
Yes.
The next one is another violation of Rule 3, and the charge is the defendant failed to submit written documentation of the intensive outpatient programming enrollment as directed. You familiar with that charge?
Yes.
And the state is pursuing those two charges?
Yes, Your Honor.
Then the next one is dated May 26th, of 22, the affidavit.
What was the last one, Judge? May what?
The affidavit, May 18th.
I have a copy of that.
I thought you said May 18th, and there was another one after May 18th.
Yeah, May 26th. That's when I'm just starting to read.
Sorry.
May 26th. Rule 8 requires sobriety. It says that the defendant tested positive for cocaine on a urine sample submitted on May 23rd, 2022, when run on May 25th, 2022. Was this after Meridian or before Meridian?
It would have been after Meridian.
So what happened at Meridian? They didn't address your problems there, or you just didn't obey their, or it didn't work on you for some reason?
The Meridian program went great. They said I passed it with flying colors.
But you did cocaine, alleged to have done cocaine after that.
The metabolite,
You know, interestingly enough, Judge, I have a drug test that he took on May 27th, which was at another facility that he was attending. I don't know if probation had all this information, but I think there was a period of time when he left Meridian and then went into another program on his own and was having some emotional and some mental issues resulting from an infection that he had. But I do have a lab result here from Core Alliance that shows he is negative for cocaine and cocaine metabolite. I'd be glad to share that.
Were there levels of reporting higher than Lake County probation levels?
I do not know the answer to that, Judge.
Because if they were set higher, I mean, if you set the level at 1,000 and, the other has it set at 100, then they'll pick up between 100 and 1,000, but the other one won't pick up until you hit 1,000.
I don't know. I know this was a drug, state certified drug program, so I would think that they would want any indication of drug usage. So I don't know what they set it at, and I don't have the levels here, but I can show the court the results.
I'm just trying to get the lay of the land here.
Yeah, okay.
All right, so that's the next charge. Then the next charge is June 8th, 2022, and it alleges a violation of Rule 3. Defendant failed to report on May 31st and June 6th. The defendants made no attempts to contact the officer. You familiar with that charge?
Yes.
And I'm assuming that there was no contact that there was contact between May 17th and May 31st. That was the positive test, right? Okay. Okay, so that went to the Hamilton County Crime Lab. All right, and they're recognized as the best in the state for that? All right. So the next one says the defendant failed to call in as directed on June 2nd and made no attempts to contact this officer. That's all on the June 8th addendum. Then the next one is the December 12th, 2022 addendum, and Rule 1 requires obedience to the law. The charges, the defendant's charged with failure to appear in case number 22 CR 972 through the Lake County Court of Common Pleas through a secret indictment. That's the second case that we have here today. The next charge is a violation of Rule 4, which says you have to report the address at which you are actually living and shall not change without prior notification and approval. It says the defendant's whereabouts have been unknown since May 31st, 2022. The defendant was arrested at 35670 Lakeland Boulevard, East Lake, Ohio, which is an unreported address. You familiar with that charge?
Yes.
And then a violation of Rule 8, requiring sobriety, says that on December 7th, 2022, this officer heard the defendant report to corrections officers in the Lake County Jail that he used Percocet, marijuana, and speed. Speed, methamphetamine, or what?
The THC I can condone to, but I don't accept the results of the other drugs.
All right, well, okay, that's what they have trials for. And then the last one on this charge is that the defendant tested positive for marijuana and cocaine on a sample collected on December 7th. This screen was run on December 8th. The same sample tested positive via dip test for fentanyl and LSD. You're familiar with that charge?
We're familiar with the charge, yes, Your Honor.
Pardon?
We are familiar with the charge.
Okay. So, is there an agreement by the defense as to the validity of any of these charges?
We're prepared to answer to all the non-reporting charges, Judge, and the marijuana in the system charges, and I think that gives the state or the court the authority to find him in violation. We questioned some of the greater drug charges. We never did any LSD. Really hasn't done the Percocets that they're referring to. Not denying use of marijuana or the fact that he failed to report.
Oh, I thought you said you were... You're agreeing to the non-reporting.
All the non-reporting were...
And the marijuana ones.
And the marijuana.
But all the other ones, the cocaine, LSD...
You know, one of the cocaines may have been valid, but I don't recall which one, but I believe I know they sent that out to Hamilton County. I don't know the whole chain of evidence on the whole thing. And I do have on the 23rd the same. I think she was talking about May 22nd. What were you talking about? Yeah. Okay, so a sample taken on May 23rd. We also had a sample from May 23rd. I can show that to the court, which shows he's negative. I'm not going to deny that he's had a history of drug use in the past, and that he found going to Meridia very helpful, and he's highly motivated and hasn't been doing drugs. He has been using marijuana for anxiety. So we admit they were in violation for a number of the things that I indicated.
So, the defendant previously waived probable cause in writing on the violations. He's here for a final hearing on the violations. You understand that if you admit to even one violation, then what I told you I would do if you violate my order will come to pass. You understand that I'll revoke your intervention plan, find you guilty, and give you an appropriate felony sentence, which would be 6 to 12 months in prison. You understand that?
Yes, Your Honor.
And have you discussed with your attorney the waiver of your final hearing, a plea of guilty to any one, more, or all of these violations, and any other options you may have at this point?
Yes, Your Honor.
And has he answered all of your questions to your satisfaction about all of that?
Yes, Your Honor.
All right, so that first violation was withdrawn by the state, failing to go to Meridian as ordered. The second and third violation, the May 18th one, failing to report and failing to submit written documentation of the IOP? Or did you submit written documentation of the IOP?
I went and called into an IOP program and said it wasn't available until June. So 1 or 2 months after I had called. And then at that time is when I started to see an outpatient program, Billy Merton.
And did you end up submitting the documentation from that?
I do not recall, Your Honor.
Kaylee, do you have written documentation that he enrolled in the IOP?
Your Honor, I did file paperwork when I went to have Billy Merton send over information from everything I was doing there to the probation department. I don't know if it ever made it, but I did fill out the paperwork I needed to when I was going to the program. Drug screens and all. Everything that was being consented by me in the program I was going to.
So how do I know that? Because that's a charge here.
I thought that was sent to probation. I got into this thing late. I do have copies of the Core Alliance. I thought Meridia had been confirmed. Hold on a second. I thought Meridia had been confirmed. He did complete the program.
Correct.
And then on his own, he went to this other program, which I have the results of that here. If the court would like to see this, or I can hand it to probation now if you'd like. I thought it was all sent to probation. I didn't go check with probation. I just looked at the pre-sentence report.
The probation department filed the charges. Give that to her, and you tell me whether you want to stand on the violation and whether the state wants to pursue the violation or withdraw the violation.
But it is my understanding that you did complete the Meridian program entirely, is that correct?
Correct.
You got a certificate for that?
Correct.
Okay, is that the written documentation that you were referring to? In this, that's not. No, I want to know, it says, the defendant failed to submit written documentation of IOP enrollment as directed. And that was filed May 18th, 2022. I need to know, is that being pursued here? Is that being admitted to, or what?
That violation was referring to the fact that on his completion, there's discharge paperwork from Meridian, their aftercare recommendation for that being an IOP. Once I received that, I informed the defendant that he needed to get involved in an IOP, and I needed verification of that.
And what he showed you just now is that he completed Meridian.
Well, you know he completed Meridian now, though, correct?
Yes.
So she's saying that he completed Meridian, but you're saying he should have gotten enrolled in an aftercare, is that what you're saying? An IOP, which I'm providing her right now information that he attended an IOP.
Does that satisfy you?
This is a all evaluation, there's no recommendation for IOP, but
What's the state say as to the second one on the May 18th?
If I may confer with Ms. One. The state would withdraw that violation.
Okay, then on the May 26th, 2022, that alleges that the defendant tested positive for cocaine on a urine sample submitted May 23rd, 2022. You're saying that didn't happen?
What I'm saying is on the 23rd, we have a test here that shows he was negative. So on that issue, did I show this to you? Do I see it?
If I may, Your Honor, Mr. Perez said that the test was from the 23rd. The test that was provided to the state
was the 27th.
Okay, so he was given another test on the 27th? Is that what you're saying?
Well, that's what you're saying.
No.
Did you test the same sample that they tested?
Wasn't he tested by the county on the 22nd or the 23rd? All right, so the test I have here is also the, oh, I'm sorry, it was the 27th, correct.
Right, so that's 4 days later.
23rd. Yeah, that's correct.
And his levels would have dropped unless he was re-administering.
Possibly, yes. Correct, Judge. I would think so.
So I can only talk to...
Pardon?
Ma'am, I'm trying to not be confused. I can only talk to, right now I'm trying to have a conversation with 3 people. I'm just trying to straighten this out. So, are you admitting to this one? Are you withdrawing it? What am I?
Not withdrawing it.
You're withdrawing it?
We are not.
You're not withdrawing it. Mr. Perez, do you want me to set this for a trial?
No. I do have, I guess I do have a collection on the 20th and the 27th. I don't think that's the only 2 I have, correct?
We had 3 that week, right? We had the doctor. He tested clean in the beginning of the week on Monday. Then we had court on the 23rd for my other attorney lying to you. And then he tested with Lake County probation on the day we went to court to see you on the 23rd. Then my doctor called me the next day and she said, bring Ronnie in. And I said, why? She goes, because they put a warrant out for him for dirty urine. I said, how could that be possible? He was just in your office. She said, bring him in. She tested him and he was clean. And I just want to let you know, he was tested 3 times that week. In the beginning of the week, then court tested him, and I paid Mr. Perez to send that urine sample out. I believe it went to Washington. And it came back where they said it was only a metabolite. So I don't know if you got it from touching something, but I do have 2 other drug tests in that week that he tested negative with the doctor.
That was the 20th and the 27th.
The state was never provided the collection that was apparently taken on the 20th, so the state can confirm that.
Okay, I'm gonna put this one on hold. Then the next one is the June 8th, 2022. Said the defendant failed to report May 31st and June 6th. No attempts to contact. The second one, defendant failed to call in as directed June 2nd, made no attempts to contact. That one you're admitting to, right?
Correct. For 1 second.
June 2nd one. It's after my probation. Recording this change for tried to call in 3 times a week. It was one time on the first time I was calling it. Even then my father started to call.
I guess the June 2nd one is his rules of probation changed and he was supposed to call in 3 times a week. He called in numerous times that day, is that correct? And didn't get a hold of anybody. So he feels for the June 2nd, he did comply.
So he was directed to report physically in person once a week and call in once a week. He did not report, but he reported the Monday, the Thursday of the June. There was one Thursday that I was out of the office to do an emergency. He had left me a voicemail, he was not violated that day. The June 6th violation was for him not physically reporting in the following Monday.
But what about the June 2nd?
I don't have the June 2nd one.
Well, it's on your affidavit dated June 8th.
I just don't have it written down on this one.
All right. While they're contesting it, you withdraw that one?
If I may speak with Ms. Warren. The state would withdraw the June 2nd violation.
Okay, then the next one is the December 12th. The first one, defendant charged with failure to appear. That's the rule that requires obedience to the law. Once he pleads guilty to that, then he will have failed to obey the law. And he's going to be pleading to that, is that correct?
Correct.
All right,
That's
so.
on the recognizance bond?
Right.
Yeah.
Okay, so the Rule 1 violation on the December 12th, you're going to admit to that one.
Correct. Show for hearings. Not on that date. December.
Okay, the next one,
What was that date, Judge? December?
the date of the affidavit?
The date of the violation for not appearing?
Oh, it doesn't say, it just says the defendant has been charged with failure to appear.
Got it.
That would be probably
wanna
the date of the
clarify.
indictment, that would be the
Correct.
date of the indictment.
Exactly.
Okay, then the Rule 4 violation about reporting the address at which you're actually living. It says the defendant's whereabouts have been unknown since May 31st, 2022. The defendant was arrested at 35670 Lakeland Boulevard, which is an unreported address. Were you living at that address?
No, Your Honor.
Okay. How do you know he was living at that address and just wasn't there visiting?
When I spoke to the officer that arrested the defendant, he told me it was considered an insurance worker, and it was because there were people living there, and he was arrested there.
Were there,
His whereabouts are unknown. It was not reported that he was living at his address. I was having to contact him to find out where he was.
how do you know he wasn't living at his address?
There's no sufficient evidence. I don't have physical proof of that, but
Well, where were you living?
At the 417 East 307.
The address at which you were supposed to be living at?
Correct, Your Honor.
Kerfoot?
The state would withdraw that violation.
Okay, the third one on that, the officer heard the defendant on December 7th report to corrections officers in the Lake County Jail that he used marijuana, Percocet, and speed. Speed's in quotes. Did you say that to a corrections officer?
No, Your Honor. Like I said, the only thing I ever said was that I was taking the marijuana gummies and at that time I was in bad health. You can see my whole body scarred from an infection I had. I had it since mid-March, and it had just started to heal over. I've been to the doctors numerous times, Euclid General, Minute Clinics, had blood work done. There was at one point I was in such bad health that I was in the hospital for a day and was being pumped with saline because they said my immune system was so bad. And I was also contagious, and they didn't know if it was MRSA or a staph infection, and I was told to not be by anybody. I could possibly be so infectious. And I believe one of the violations where I didn't report, I was told by Craig Berry to bring in 2 forms of paperwork from the doctors when I went to Euclid General, and I brought one into probation, and I brought one into Craig Berry himself. And I believe that it's one of, I think, the June 2nd violation of not reporting. So there should be paperwork on probation's.
But December 7th, you didn't tell the officer you used marijuana, Percocet, and speed?
No, Your Honor.
Do you have evidence? You heard that?
I heard it, and then Craig Berry also heard it over in the jail. It was documented on their system. I don't have to know that, but I'm sure that's
The state would not be withdrawing.
What did you say?
It will not be withdrawing that violation.
Does it indicate whether he was referring to something that happened in the past or in the present? When he made that remark, because they ask you whether you've ever taken any drugs, does that indicate, was it an indication that he was presently taking those, or that those are things he'd taken in the past? Because typically when they ask you that stuff, they ask you what drugs have you taken, in your life, basically, is what most people think. Do you know how to distinguish what was said? Was he saying, I just finished taking that stuff? Or he was just responding that, yes, I have taken all this stuff?
Well, to prove that, the state would have to bring in the corrections officer and Chief Berry and Officer Warren.
That'd be correct, Your Honor.
All right.
I would like to add, Your Honor, I've never said in my entire life that I've used speed or any other drug of that sort, and my case has revolved around the opioid case, and I've been honest and forthcoming about everything up until today. I've always been honest, even the first time that we had met. So I would like to add that, and I would like to also apologize for the not appearing at court. But like I said, I was in very
well. Let me move on.
Okay.
Then the fourth violation says the defendant tested positive for marijuana and cocaine on a sample collected on December 7th. The screen was run December 8th. Tested positive via dipstick for fentanyl and LSD.
You deny LSD and cocaine, is that correct?
Correct. And fentanyl. Well, really.
We don't deny a marijuana, Judge. We deny fentanyl, cocaine, and LSD. And I don't know if those were those sent out to the crime line?
Is the sample still available? All right, well then, it should be sent out to the crime lab for confirmation. Okay. So you're entitled to a final hearing on these, and we'll set the two issues, I think, that have been identified for a final hearing later on. But do you give up the final hearing on the ones that we talked about that you're admitting?
Yes, Your Honor.
And you understand your exposure is the full measure of what I told you, revocation of intervention, finding you guilty, and a potential prison sentence of 6 to 12 months.
Yes, Your Honor.
And have you discussed with your attorney the waiver of your final hearing and a plea of guilty to those violations, and any other options you may have at this point?
Yes, Your Honor.
So do you give up the right to a final hearing on the ones that we're going to be talking about?
Yes, Judge. I think the only thing that he questioned was the June 2nd. I don't know if you found, I think he may have mistakenly admitted to that. That was the one where he actually dropped the material off to the probation officer, to Frank Berry. I think that's the one. There's so many, I'm kind of confused here. Wasn't that information dropped off on June 2nd? That was, I believe, a failure to provide that information, or?
The June 2nd violation was for failing to call. The state has already withdrawn.
Oh, you're withdrawing it?
Yeah, the June 2nd, not the June 6th. I don't believe the court addressed the June 6th.
That's the only one we're contesting. Yeah, we're good then, Judge.
All right, so the charge for failing to report on May 9th, May 10th, and May 17th, what's your plea?
Guilty, Your Honor.
The charge for failing to report on May 31st and June 6th, what's your plea?
Guilty, Your Honor.
the charge on failing to appear, which resulted in case number 22 CR 972. What's your plea?
Guilty, Your Honor.
Court finds that the defendant has knowingly, voluntarily, and intelligently waived his right to a final hearing as to those violations. Court finds the defendant guilty of those violations and determines that they are non-technical violations because they have evidence to the court an abandonment of the purposes and principles and goals of probation. In the 22 CR 972 case, you are charged with failing to appear. It's a felony of the 4th degree. It's my understanding that you wish to plead guilty as charged. Is that correct?
Correct, Your Honor.
Before I can accept your plea, I have to determine if you know and understand the rights you are giving up, the consequences of a guilty plea, and that you are changing your plea to guilty. He was arraigned on this already, right? Yes. To guilty of your own free will. How old are you?
29, Your Honor.
How far did you go in school?
I graduated through high school.
Do you have the ability to read, write, and understand the English language?
Correct.
Are you a U.S. citizen?
Yes.
Are you currently under the influence of any drugs, alcohol, or medication?
No, Your Honor.
Have you taken any within the last 48 hours?
No, Your Honor.
Have you received a copy of the indictment? The charge?
Yes, Your Honor.
Did you read the charge?
Yes, Your Honor.
Do you understand the charge?
Yes, Your Honor.
Did you discuss that charge with your attorney?
Yes, I did.
Did he answer all of your questions to your satisfaction about the charge?
Yes.
Do you agree that the charge describes what you did here?
Yes.
And you wish to plead guilty to that charge?
Yes, Your Honor.
I've been handed a 4-page document called Written Plea of Guilty. You probably went over this document with your attorney before we started the hearing, is that correct?
Correct.
And did you read this document?
Yes, I did.
You understand it?
Yes, I did.
Did you discuss this document with your attorney?
Yes, I did.
Did he answer all of your questions to your satisfaction about the document?
Yes, he is.
Do you agree with what it says?
Yes, Your Honor.
And do you wish to sign it?
Yes, Your Honor.
I'm going to go over the charge you are proposing to plead guilty to so that we are all on the same page. The charge says that on July 18th, 2022, in the city of Painesville, Lake County, Ohio, you failed to appear as required on case number 21 CR 000867 after having been released pursuant to section 2937.29 of the revised code. The release being in connection with the commission of a felony. That's called failure to appear. It's a felony of the 4th degree. It's in violation of revised code section 2937.99. Do you understand that charge?
Yes, Your Honor.
And is that the charge to which you wish to plead guilty?
Yes, Your Honor.
You understand if you plead guilty to that charge, you are admitting you committed the crime.
Yes, Your Honor.
You understand that if you had any defenses to that charge, you give up those defenses by pleading guilty.
Yes, Your Honor.
You understand by pleading guilty, you are giving the court the power to sentence you immediately.
Yes, Your Honor.
You understand that any rulings previously made by this or any other court on this case prior to this moment could not be appealed because you're pleading guilty now.
Yes, Your Honor.
And you understand by pleading guilty, you cannot later make a claim that your attorney did not perform as a reasonable, competent attorney in rendering services on this because you're pleading guilty at this point.
Yes.
You You have certain trial rights. You're giving them all up by pleading guilty. I'm going to explain them to you one at a time. I need to make sure that you know and understand you have these rights and that you're voluntarily giving up these rights. As I explain your rights to you, if you have any question about what I'm saying or if you need a better explanation, you need to speak up and let me know. Otherwise, I will assume you understood and answered the question that I asked you. Fair enough?
Fair.
And these are the same ones that I went over with you on March 7th, 2022. So there'll be a lot of familiarity with these. You don't have to plead guilty. You have a right to have a trial. That trial would automatically be by a jury in this court unless you decided you wanted the judge to make all of the decisions. And you understand that a trial gives you the ability to test every aspect of the state's case, both factual and legal. And if you had a jury trial, the jury's verdict must be unanimous before they can convict you. Do you understand all of that?
Yes.
Any question at all about any of that?
No.
The state of Ohio is required to prove your guilt beyond a reasonable doubt. By pleading guilty, you're relieving them of any obligation to prove anything, let alone beyond a reasonable doubt. So your plea can be used against you to establish everything that the state would need to prove in court for you to be convicted. Do you understand that?
Yes.
You have the right to confront your accusers, meaning to have your attorney question all of the state's witnesses under oath in front of the judge and jury. Do you understand that?
Yes.
You have the right to use the subpoena power of the court to compel witnesses you need to come here to testify for you. Do you understand that?
Yes, I do.
You have the right to tell your side of what occurred here and testify in your own defense, or you could refuse to testify. It's one way or the other, but it is your choice. No one can compel you to testify if you did not want to, and if you chose not to testify, that could not be used against you to prove that you were guilty. In fact, the prosecutor could not even comment on your silence to infer you might be guilty of something to hide, maybe have a prior conviction. The jurors would be told you have the constitutional right not to take the stand and testify. We would select only individuals to serve as jurors. In your case, who answer under oath during jury selection, that they will uphold that right. Do you understand that?
Yes, I do.
You understand that if you were not pleading guilty today, you would always be represented by an attorney at law, even if you could no longer afford counsel. Counsel would be appointed by the court, paid for by the taxpayers, free to you.
Yes, Your Honor.
You understand that if you were not pleading guilty today, you could appeal any of the decisions I would make throughout this case. You could appeal the jury's verdict. You would have a transcript typed up of everything that was said or done in this court, so you can demonstrate to a higher court any mistakes made here to get those mistakes corrected, and an attorney to handle that appeal for you. And if you could no longer afford that, all of that would be provided to you free of charge, paid for by the taxpayers. Do you understand that?
Yes, I do.
You understand plea of guilty is a complete admission of guilt?
Yes, I do.
You voluntarily give up all these rights that I just explained to you and wish to have this court accept your plea of guilty to one count felony for failure to appear.
Yes, I understand.
So you understand by pleading guilty, you are voluntarily giving up your freedom for whatever length of time I sentence you to prison, jail, or community control.
Yes, I do.
You understand on this charge, I can send you to prison for a whole number of months between 6 and 18. I can make the sentence on this count consecutive with prison on the other case of 12 months for a total of 30 months in prison. You understand that?
Yes, I do, Your Honor.
You understand that I can fine you up to $5,000 on this count.
Yes, I do.
You understand that while in prison you may be eligible for, be offered, and be able to earn some credit against time to be served by engaging in programming offered to you for that purpose. The prison credit is normally capped at 8% of time to be served or a certain number of days according to their regulations.
Yes, Your Honor.
On your release from prison, you could be on post-release control, PRC, in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. They give you rules, you violate their rules, they can return you to prison for up to 9 months in this case, even for one violation. All of that time is part of the sentence. Do you understand that?
Yes, I do.
If your violation of post-release control is a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired on that potential 2 years of PRC. All of that time is part of the sentence. Do you understand that?
Yes, I do.
You understand that if I chose not to send you to prison, I would place you on community control sanctions for a period of up to 5 years.
Yes, I do.
And you understand that that can overlap the community control if I kept you on community control in the other case, or it can be consecutive to the other case, but under no circumstances would the combination of them be longer than 5 years. You understand that? You understand as part of the community control sanction there'd be various other conditions that I would impose on you, very similar to the other case, which would include time in a local jail and treatment I determine you need, substance abuse or mental health, abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, anything I determine you need to do. You understand you would be required to perform exactly what I tell you to do, exactly how I tell you to do it.
Yes, Your Honor.
Now, you understand that based upon the sheer number of probation violations alleged here, including some that may not be entirely provable, but there's probable cause, that we enforce these orders. I would be hoarse if I just gave you orders and things to do. I gave you an extensive intervention plan. I didn't do it to exercise my vocal cords or my writing, the judgment entry. I did it because that's what my job requires me to do. I determine what is required and I order it and we enforce it. You understand that?
Yes, I do.
So I just don't want there to be any mistake here that if I don't send you to prison, prison's easy. I just tell you, okay, 8 months, 10 months, 30 months, and I'm done with you. If I put you on probation, I'm giving you a chance. I'm working with you. You have to work back. You understand that? And there's very little tolerance for mistakes here. Understood?
I understand.
So you understand if you fail to comply with the order, I can extend the period of time that you're on community control for up to the 5-year maximum. I can increase the nature and severity of the other conditions under the community control, meaning more time in jail, more treatment, more things to do. Or I can terminate community control altogether and just send you to prison for a maximum consecutive sentence. Do you understand that?
Yes, I do.
In addition to the fine that I mentioned, you understand I will order you to reimburse the government the cost of confinement, community supervision, treatment, and court costs.
Yes, Your Honor.
And you understand the cost of confinement also includes transportation costs between the court, the jail, and the prison institution.
Yes, Your Honor.
You understand I will enter a judgment against you for the costs of prosecution.
Yes.
If you fail to pay that judgment or timely make payments on a payment plan approved by the court, you may be able to substitute community service to work it off. By local rule, you'd work it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. You understand that?
Yes, I do.
You understand a failure to pay all fines and costs in full can result in the state blocking your motor vehicle license plates until they are paid in full.
Yes, Your Honor.
Do you understand all the potential penalties?
Yes, I do.
Do you understand that also this will go on your record, and the next time you have a criminal offense and you come up for a bond hearing or bail hearing, that can be used against you to show that the bond should either be higher, there should be a cash bond, or you should get no bond at all and be kept in jail. You understand that? You understand no promises have been made by the court, the prosecutor, your attorney, or anyone as to what I will do when it comes time for sentencing.
I understand.
No one can promise you what I'll do because that's solely my job. Has the state of Ohio promised you anything in order to secure your plea of guilty to this charge?
No.
Squarefoot, have you told Mr. Perez that you would be recommending that I don't send Mr. Samueli to prison?
The state has only agreed to a joint recommendation with Mr. Perez for community control sanctions.
Right, that I wouldn't send you to prison.
That's correct, Your Honor.
Okay. So were you aware of that? I don't know if Mr. Perez had time to ask you about that or tell you that. Were you aware that if you pled guilty here, both sides would be asking that I don't send you to prison?
Oh, correct.
You were aware of that?
Correct.
Okay. So when I said, has there been any promises, that's one of those promises that you probably were relying on, weren't you?
Correct.
Okay. Or it didn't matter to you that the prosecutor's not going to be banging his hand on the table saying, send this guy to prison?
Correct. That was, I don't want to say promise, but that's what I was told we were shooting for.
Okay.
So.
But the point is, I'm not bound by that.
Correct.
So I can say, I don't care what you guys say, I'm still going to send this guy to prison.
Correct.
Okay.
I understand that.
Has anyone else made any promises or threats to you in order to get you to plead guilty?
No, Your Honor.
Are you entering this plea freely and voluntarily?
Yes, I am.
Have you told your attorney everything you considered important in this case?
Yes.
Did you hold back anything from him?
No.
Have you had enough time to discuss what you're doing in this case with your attorney?
Yes, I have.
Although this may be your attorney's recommendation for you to plead guilty as charged, is this your own decision and voluntary act to do so?
Yes, it is.
Has your attorney done everything you've asked him to do for you in this case?
Yes, he has.
And are you completely satisfied? Did I ask that right? Has your attorney done everything you've asked him to do for you in this case?
Yes.
And are you completely satisfied with the legal representation provided by Rick Perez, your attorney?
I am satisfied, yes, I am.
Squarefoot, I'm assuming I set it for a hearing, I ordered him to appear, he didn't appear, my bailiff testified to that fact in front of the grand jury, and you got an indictment.
That is correct.
Okay. Do you agree that that's what happened here?
Yes.
What's your plea to the charge of failing to appear, a felony of the 4th degree?
Guilty.
I'm going to hand you the written plea of guilty document that we talked about earlier, the 4-page document. Make sure you've read it, make sure you understand what it says, make sure you agree with what it says, and if you sign it only because that's what you want to do. My markings are in red, so you can easily tell what I've done to it since you last saw it.
That's the same document we looked at. Flip the pages. One more page. This. And everything else is good. We go ahead and sign.
It's the 4th.
Today is the 4th, yeah.
The witness, the defendant signed this written plea of guilty here in open court and is signing as a witness. May I put you on?
Yes. Court will sign the judgment entry at the end of the written plea of guilty and make it part of the record. Record should reflect that Ronald J. Samueli was here with Attorney Rick Perez in open court. I informed Mr. Samueli of all of his constitutional rights. He's made a knowing, intelligent, and voluntary waiver of those rights. I find he understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept his plea and find him guilty as charged. Failing to appear, failure to appear, felony 4, revised code 2937.29. The defendant has waived any further pre-sentence investigation and report. So I am sentencing him on the 3 probation violations to which the defendant pled guilty. All of the remaining ones are dismissed or withdrawn. We're not going to do a trial on what he said to a corrections officer or
Thank you, Your Honor.
the dipstick. Any reason not to proceed to sentencing?
No, Your Honor.
And, by the way, the court has considered everything. I'm terminating the intervention plan, finding the defendant guilty of the F5, what was the original charge? Possession of a fentanyl-related compound?
That's correct, Your Honor.
And I'm sentencing on both that and the F4. Mr. Perez, you may address the court.
Thank you, Your Honor. Your Honor, Mr. Samueli obviously apologizes to the court. I don't think he ever meant to disrespect the court or the probation department. He was having a lot of issues. I think he had some issues with his first lawyer that kind of scared him about what could happen in court. Meanwhile, the little amount of time that he spent in jail before, he believes he contracted some disease, and I would ask you to just approach the court and stand about 5 feet away from the court. I'd ask the court to just take actual knowledge of the scarring. Would you just walk over there? If that's okay with the judge, can I have him walk over there?
Yeah, but I believe him already.
All right.
I mean,
And just tell the judge briefly what you've got going on and what you had going on.
Throughout the sickness that I had, like I said earlier, with 4 different places that I worked on. At one point, my immune system, I was so feeble, really wasn't able to taking care of myself and bedridden, but I struggled with them. And then at one point, my immune system, I was totally so low that I should be in hospital care. That's when I was at Salem, when we were saving and get my immune system back up. And so the skin coming out from the myself, and that had a lot to do with some of the violations that I had. So clearly better than it. To the point of saying you can't get I'm not sure it's still going but during that time, no disrespect at all.
all right, I understand.
Why don't you have a seat back over here again? And you have what is on your face is on different parts of your body too, is that correct?
Correct.
Without showing the court, just kind of give them an idea where else it is.
My whole torso area, and was starting to go farther down to my waist and so on. So about 60% of my body.
Oh, you can have a seat. So I think this caused him to be, it caused an emotional issue for him. He was afraid he was going to be put in jail again. He felt the jail was the source of this. He was trying to get treatment. Meanwhile, there was some confusion initially as to whether or not he was in a treatment program, when it turned out he was, and the way that whole thing was sort of handled for him scared him and kind of kicked him off to just be afraid of the whole system. So he did try to report. He did go to a couple of times, I believe. He brought some information into the probation department. He then enrolled in another program, which I referred to, which was the CARE Alliance program, Stokes Clinic, where actually they gave him Suboxone. Is that correct?
Correct.
And he was on Suboxone and he was tested, and that's when I referred to those negative testings at that time, where he was positive for Suboxone, which he was prescribed, but negative for the other drugs. In any event, he somehow developed issues with whether probation was really working with him or against him, and I wasn't really privy to a lot of this stuff, and I don't blame the probation officer here for any of that, but I think it was some of the confusion, some of his fear of his illness, of his inability to really function and get out of bed and do things, and what the consequences that he feared, that he did things that he typically wouldn't do. I mean, he'd worked for 7 years in another job, that he reported regularly that he was a good worker. He got some additional certificates for working there. And all these things started to fall apart in his life. So there may be more here to it than just what happened with his disease and his probation that may have started before all this happened, I think, because he was having some emotional issues. His mother is here. She could explain a lot of things to the court. I don't know if the court wants to hear a lot of it, but I think what she would tell you is that he's really kind of a good kid. He's done a lot of things. He really was motivated to do everything right, complete probation. He's got no prior criminal history as an adult, other than these two specific offenses. And they kind of go hand in hand, because his failure to appear kind of goes hand in hand with his failure to report. I think there's some other things going on here. I don't know that they're drug-related issues. I think he's got some other issues that he's been trying to cope with. I would ask the court, obviously, to not send him to prison and to give him probation. And I would ask the court to more fashion a sort of probation that would allow him to remain and live at the residence that he's living at now with his mother, engage in an aftercare program, one of which he actually applied to and started, but because of all these other things did not finish.
Where's he getting his care from now?
Right now, he's just been incarcerated since December 6th.
Or before he was incarcerated?
Before that, he was going to CORE Alliance at Stokes Clinic in Cleveland, but I think he'd prefer to go somewhere in Lake County. Is that correct?
Either
The Signature
Health?
Signature or CORE.
Signature or CORE is fine. He's very motivated to do this. He would like to try and get his old job back, and I understand that's a possibility. So I'm asking the court to put him on probation and to allow him to live with his mother, to set up some rules that the court wants to set up. He's indicated that he is drug-free, that he intends to remain drug-free, that he will go to an outpatient program. I've discussed with him that it's going to take a lot for this court to put that kind of faith in him again after what he's done in the past. He realizes that he would like to establish and show to the court that he does respect the court. He does appreciate the court's prior efforts to put him in the intervention program. And he is he's going to seek some psychological counseling as part of this whole thing. As far as the treatment for his medical condition, you're scheduled to see another specialist in February, is that correct?
Correct.
And That's been another concern, and he doesn't know how, we don't know how that affects his mental condition or since his immune system is suffering as a result of this. In any event, we're asking the court to consider probation, an IOP that, and I understand you have Medicaid that will help pay for that, is that correct?
Correct.
Allow him to try to get back to work again and get his act together, and he's hoping that the court has enough confidence in him at this point to believe that he will report to probation. I think he gets along with the probation officer, is that correct? I don't think he's a big fan of Craig Berry. And that might be for some other reasons that his mom would like to share, but I'm going to ask her just to really not share anything else today and ask the court to grant probation. I think he'd like to tell a few things to the court, Judge.
Ronald Samueli, the law allows you to say anything else you want me to consider?
You can talk to him about whatever you want to talk about. He wants to understand why he thinks you'd be a good candidate.
Well, first of all, like I said before, Your Honor, I meant no disrespect and have not lied, not once, coming into this courtroom. I come from a good background, and like Mr. Perez said, I would like to try to get my old job back where I was a level 2. I put a lot of effort. I put years of effort into that. Really, I would like to just have a fresh start and be able to do this in good health and good faith and get my old life back. And I've had, last year was not a good year for me, and a lot more has happened in that 1 year in my life than multiple years combined, and it's been rough for me. And I think a lot of leading up to this point had to do with my mental capacity, and I was never a menace to society. I was, if anything, a danger to myself, and not knowing how to cope with certain things. And for 7 years as a level 2 at my job, I worked 60 hours a week, and the only time I got off was when I used vacation time. I was overworked and stressed, but I always have had a good mentality in trying to get my certifications, and I looked at whether I was going to go to college or
what job?
Going to me doing the molecular grain inspections at Consolidated Precision Products as a level 2. I trained around 3,000 to 4,000 hours of training and took 2 federal tests to get my 2 federal certifications.
Does your health condition inhibit you from working there?
It may. So probably until February, when I find out. I still don't even know exactly what it was that I had. And I would like to move forward and, get that out of the way, get my license back. I have a car. I have the capabilities of doing what I need to do on my own as soon as I get my license, and whether it's work and not having to rely on anybody but myself. And that's something I would look forward to as well, as not having to be dependent on anybody or anything moving forward. Having my life back in my control. I would very much appreciate the consideration for, me being able to start out fresh again.
All right, let me hear from the state.
Your Honor gave the defendant a chance to show that he could be on probation and successfully complete it and get treatment. And he has multiple violations for not complying with the rules of probation, not speaking with his probation officer. So the state does have concerns about putting him again on community control. But the one thing that is preventing the state from making that recommendation is that he doesn't have an extensive criminal history. The facts of this underlying case, there's no victim, it's an F5. The state is hesitant to see him put on probation again, but the state does think that putting him on NeoCap, putting him in the NeoCap program, where he's under more supervision, tighter supervision, tighter control, is appropriate in this matter. So therefore, the state would recommend community control and placing the defendant in NeoCap. Thank you.
What's the credit?
On the probation violation, in the case of 29 days, there's 51 days total.
51?
51 total.
51 total. Do you agree?
That's not correct.
That's
That's
not
before, that'd be before your
Incarceration
prior
time.
and present incarceration, 51
Jail,
days.
minus the Meridian program, just jail time in general.
Yeah.
Yes, Your Honor.
And all that time is on the 21 case, none of that's on the 22 case.
That is correct.
I've considered the record, the oral statements made, pre-sentence report, the intervention workup, my conference in chambers with counsel on probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've considered the joint recommendation of the parties for a community control sanction. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders, and using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I've considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. There are no factors making the offenses more or less serious in terms of recidivism. Defendant has a minor criminal history. There has been a failure to respond to community control. There is a pattern of substance abuse. In terms of making recidivism less likely, the offender is genuinely remorseful and has a support structure. The court knows firsthand that a lot of this problem came about by your prior representation. Court believes that community control is appropriate here. The court will adopt a joint recommendation placing you on 2 years of community control, which starts today. The other one was intervention. That's been wiped out. So your community control on both cases goes for 2 years starting today, so they are in sync. Subject to the general supervision and control of the Lake County Adult Probation Department under such terms and conditions that it finds appropriate. Among these, you shall not leave the state of Ohio without the permission of the court, and you shall abide by all laws, including but not limited to the laws related to firearms, deadly weapons, and dangerous ordnance. The court further imposes the following specific sanctions and conditions. On the 21 case, a period of incarceration in a Lake County jail for 52 days with credit for 51 days. On the 22 case, no jail time, no credit. On all counts, all cases, you are to engage signature help for substance and mental health services. You're to complete an IOP if it hasn't been completed, following all recommendations, including aftercare recommendations. You'd have complete abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance. You're to attend a minimum of 3 12-step program meetings per week, have a sponsor, and be involved in a home group. You're to attend to your medical conditions. You'd have full-time employment or school if your health permits, or a combination of employment and school, but outside of any establishments that sell or purvey alcohol or drugs. You're to have an initial psychiatric or psychological consultation and follow all recommendations. 1 doctor, 1 dentist, 1 pharmacy at any one time in any one specialty. Prescribing or filling prescriptions for you. You're to inform the adult probation department of any change of provider and sign medical releases so that they can monitor drug-seeking activity on your part. You're to inform your providers of your addiction. You're to take all medicines as prescribed. You're to reside with your mother. How old are you?
29, Your Honor.
You're to pay the costs of prosecution, confinement, community supervision, treatment, and court costs. A violation of this order will result in a prison term on the 21 case of 12 months, on the 22 case of 18 months consecutive for 30 months. If you do end up in prison, I told you about post-release control, up to 2 years. They can return you administratively for up to 1/2 the original prison sentence, and up to 9 months for any one violation. If the violation is a new felony, the judge in a new felony case can add on this case, terminate supervision on this case, and impose the greater of 1 year or whatever length of time remains unexpired on the PRC. I told you about the 8% credit, substituting community service for costs, and the state block on your motor vehicle registration. Bond in both cases is released. Anything further from the state?
No, Your Honor.
Defense?
No, Your Honor, thank you, Your Honor.
Probation?
Can